May I please your lordship? Lordships, I beg to mention item number 13, which is connected with 14. On behalf of Mr. A.M. Bora, lordship, kindly the matter may be taken up some other day after 2 weeks.
Okay, Madam, we have M. Bora and the consent the appellant. List of the 2 weeks.
Highly obliged.
May I please your lordship? So the appeal was filed on lordship 26th of April, lordship. It has not been listed yet for the first time. Also. So kindly take up for 26th, lordship. 26, 23, lordship.
Yes, 26.
26, lordship. Obliged.
May I please, your lordship? My lord, I beg to item number 15, my lord. My lord, this matter may be taken up, my lord, another date, my lord.
No mentions leave again here.
My lord,
What happened?
my lord, because another part of matter is, my lord, fixed to listed today, my lord, in court number 7. It will take some more time, my lord.
Would have mentioned it. Yes, Mr.
M. Islam.
On request made by M. Islam, Leonard Council for the appellant, list after 3 weeks. Yes.
My lord. Highly obliged, your lordship.
May I pay, Lordship, I'll beg to mention regarding item number 10, Lordship. Here I have been informed that they have misplaced their paper book, Lordship. So can it be fixed on any other fixed date, Lordship?
Misplace the paper book means?
But
No, I don't know. Our office person could not find the paper book in this matter.
can it be taken up any other?
Where also? Suresh Mandal and 7 others.
Item number
10, Lordship.
10.
10. So we'll adjourn it on your behalf.
Any day after a week, I'll
But-
find out the paper book.
Ahmed for the appellant. On request made by S. Jahan, Leonard addition. List the matter after 2 weeks.
Obliged, Lordship.
May I please? My lord, I beg to mention item 16, my lord. 1/6, my lord.
Yes,
My lord, this may be adjourned for 3 weeks, my lord.
on request made by R. Ali, Leonard Council for the appellant, list after 4 weeks.
I am obliged, my lord.
May I please your lordship? I beg to mention item number 11, my lord. Kindly pass over for the day, my lord.
No mention memo here also.
Extremely sorry, my lord. There is a part of matter is going on, my lord, in court number 1, my lord.
Yeah, Mr.
N. Burwa.
On request made by N. Bora, Leonard Council for appellant, list the matter after 3 weeks. Yes.
May I please, lordship? I prefer mention item number 7 and 8, your lordship.
Yes. Yeah, Mr.
Islam, your lordship.
Request made by Islam, Leonard Council for the appellant, list the matter after 3 weeks.
Lordship, here I am appearing for the informant, Lordship. They are on bail since 2017. In the year 2019, the matter was fixed for early hearing, Lordship, but could not take place. So may I pay for a fixed date, Lordship?
List the matter on 13th June.
Except 13, your lordship. Any other date except 13, your lordship.
15th.
Must.
Obliged. Please, Your Lordship, I beg to mention item number 9, my lord, of today's please, my lord.
Here also no mentions.
Yes, madam. I'm sorry, my lord. Senior has some difficulty, my lord. He's got some difficulty.
Okay, on request made on behalf of Mr. T.J. Mahanda, the senior counsel for the appellant, list the matter after 3 weeks.
Obliged, Your Lord.
May I please, your lordship?
Yes.
I beg to mention item number 5 and 6, lordship. Kindly adjourn the matter for the day.
Here also no mentions.
Lordship, my senior is not well, lordship.
Who's your senior?
Mr. Pija Soike.
Huh?
Mr. Pija Soike.
5 and 6.
It's a very old matter.
Automatically goes with 4.
Yes, lordship.
Uh-huh.
It is also there.
And this is a 2017 matter. I think earlier also Mr. Peter Seke was not there.
He is not well, lordship.
Okay. Heard MS B. Sharma, Leonard Amicus Curie in criminal appeal within bracket J 42 of 2017. Stop. Also heard MS S. Jahan, Leonard edition PP Assam. On request made on behalf of Mr. PG Saikel, Leonard counsel for the appellant in criminal appeal 150 of 2017. This is the matter after. How long do you want?
Next week, lordship, all matter. Next
I've
week,
already
lordship.
gone through.
After 1 week.
6 appellants are there. Lordship.
Obliged, lordship.
Item 1 of daily list orders.
Yeah, please, your lordship. My lord, actually today, if your lordship will recall that baby girl
Yes.
document is to be submitted, my lord. So we could procure some of the documents, my lord, which are available in our file also. This document goes to show, my lord, that on the last occasion, we got her treated in Apollo Glenmark at Kolkata, my lord.
Let me see. Lordship, may I submit, my lord, there's an adjournment slip on behalf of the informant. She is unable to submit before your lordship. And your lordship,
Now let the informant say.
yes,
Your
because I'm told I have put the signature on the adjournment slip. And your lordship, on the last occasion, they have taken time. On the context, their lordship produced some document of the Kolkata, your lordship.
Because we are handicapped because the only male member is behind the bar.
Yes.
The wife is 45% physically
Yes,
disabled.
informant.
Lordship,
Child is there.
Lordship, today
I
my
don't-
senior is out of station, my lord. So I pray for accommodation for only for the day, my lord. So my lord may take up this matter on the next Thursday, my lord, coming Thursday. Lordship, he has to go through this lordship documents, lord.
Go through these documents does not require
Lordship,
already there. The
only for this
treatment was
day,
done.
my lord, accommodation only for this day, my lord.
Amma, what is?
Well, see, my lord,
On
this is
Thursday,
a
my lord, short.
baby angel in distress, my lord. Lordship, that part is another part. What I'm just submitting, my lord, for your lordship, kind understanding of the matter. That one angel needs treatment. Let her take the treatment. I'll come and submit the document. If my learned friend Jasus wants to make enquiry regarding that, he can do it, my lord, because he makes that type of enquiry. Because that's not part of the council's duty. But if he feels he can make enquiry, and if their documents are not satisfied, your lordship will cancel my bail immediately. my lord.
Lordship, may I say, because the interest of the child is also there, may I see the order of where they have made the submission regarding lordship, the treatment they'll do in Kolkata? May I see the date of the order?
Which order?
Earlier order wherein you have given lordship
Petition is
submitted
there, no?
before the court.
Yes, 12
Yes. 12.5 lordship, the order, no, not this 12.5 order. Earlier where they have submitted before this.
All
honorable
stated
court.
in my petition. Can you
Yes,
have a
yes.
look in the
Date,
petition?
date, Dada, date.
Take what petition, ma'am?
No, you said submit, what?
Oh, no, মই কি কৈ আছো? তুমি বিচাৰিছা, I can give you. Petition ত চব লগোৱা আছে। কোনটো অৰ্ডাৰ লাগে তোমাক?
মানে কলকাতাতে কৰিব কৈছিলে ন?
তোমার এখন গ্যাস লিক করো। কালুকে দাঁড়ায় দিলাম। চাক করেছে।
Anyway, if informant is not present, we'll take it up day after tomorrow.
Yes,
If
ma'am.
he's not present, we are passing orders on day after tomorrow.
No, I just wanted to verify the date on which they have made
That will
submission before
verify
this
later
court,
on. Yes.
that they will take the child to Kolkata for treatment. If it tallies with this document, I have no objection. If your lordship grants bail for a particular period for 1 week or so, I have no objection, my lord. If it tallies, but I'm unable to find the date on
Let
which
the
they-
informant come
lordship.
day after tomorrow, but if he's not present, we are passing orders. Day after
Sure.
tomorrow. There will be no adjournment.
Well, can it be on 26 kindly, my lord? Because 25 I will be out of station, my lord. Either 24 or 26.
Mr. Z. Gamal and the senior counsel for the applicant. On request made on behalf of AK Buya,
Lordship.
learned counsel for the respondent. List the matter on 20.
Either 24 or 26.
Lordship 26th then, my lord. 26th.
Okay, 26.
2 and 3 hearing.
My lord, this matter was heard on length, my lord. Only the lordship's kind consideration was whether if the dying declaration is accepted, my lord, then my lord, the conviction would be upheld, my lord. If the dying declaration goes, my lord, the conviction goes. My lord. For that, my lord, I have already shown your lordship. My lord, I place before your lordship the three witnesses, my lord, the statement of all the three witnesses, my lord, who signed the, my lord, dying declaration. The fourth number witness, my lord, she never turned to the court. She never deposed a statement. As far as the first one was the, my lord, the constable, my lord, Ajit Burman, my lord. He was PW7, my lord. He said that I and Nipen Sekia, the person who filed the charge sheet. But in the statement of Nipen Sekia, my lord, the person who gave this charge sheet, my lord, the inspector of police, my lord, PW11, my lord. He in his evidence have not stated that he went down to the hospital, my lord, along with Atul Burman. That apart, my lord, the nurse, my lord, she said that who took my signatures, what she said, and who wrote the, if I may refresh your lordship. Yes, my lord. My lord, would come to page 24 first, my lord. If first witness to the dying declaration, page 24, my lord. Now, my lord, page 24, my lord, second paragraph. On 18/8/14, when I was working at Jugijan PP, information was received that a woman named so-and-so was taken to the Jugijan hospital sustaining burn injury. I, along with the investigation officer, Nipen Sekia, went to Jugijan hospital, my lord. This is the statement, my lord. Now, my lord, in the cross-examination, I'll take your lordship to page 25, my lord. My lord, third line, my lord. The woman was in a speechless state. Meaning there, the person who was signed says that she was in a speechless state. She could not speak, my lord. I did not understand what she said, what she had said. I did not see whether her husband was present or not. So, my lord, Pijus Pandit is the husband, my lord, who has also signed the dying declaration, my lord. I do not know whether she had mentioned the name of her husband or not. I put my signature when the doctor asked me to do so. I do not know whether the injured put her signature on the dying declaration or not. So, my lord, this is one of the witness to the dying declaration. Now, my lord, the second witness to the dying declaration is PW10, page 30, my lord, Geeta Devi.
Yes.
I'll directly take your lordship to the cross part, my lord. Page 31, my lord. Her face was not burned. The remaining part of her person was burned. The injured was from Bengali community. When Dr. Chaudhary asked, she was saying, her utterances were intelligible. Now she says that she was clear, loud and she was clear while making a statement. I cannot say who did write a statement. So now if a witness says that who did write the statement, because if somebody is saying, my lord, somebody would be writing that. But now this witness says that I cannot say who did write her statement. I put my signature after writing. I have forgotten who did tell me to put my signature. I did not notice who did take her thumb impression. So, my lord, she also makes certain discrepancy in this, my lord. Then, my lord, the third witness to the dying declaration was Pijus Pandit, the husband, my lord. So, for husband, my lord, I am relying on the evidence of the IO, my lord. The IO is PW12, my lord, page 34, my lord. Only the last part of the cross, my lord, I'll take page 35, my lord. From the bottom
above 3 lines, my lord. The husband of the deceased was not present at the time of treatment given in the hospital at Jugija. So this is the Pijus Pandit, my lord, the third witness to the dying declaration, my lord. So the IO, my lord, who investigated the entire case, who took the statements of all the witnesses, my lord, including the doctor's statement also, my lord. Now he says that the husband was not present. So, my lord, if I take your lordship to the dying declaration, my lord, then lordship would find there were only 4 witnesses to the dying declaration, my lord. That is at page 86, my lord. Page 86, my lord. Witness SD Constable 504 Ajit Burman. Second was Sikha Pandit. She never turned up to the court, my lord. Then Pijus Pandit, the husband, my lord. Then Miss Gita Devi, my lord. The nurse, my lord. So these are the 3 aspects. And that apart, my lord, if we see the statement of the doctor, my lord, my lord, PW4, my lord, he says that immediately after she came inside the hospital, he gave the first aid. So, my lord, the first aid would be in the shape of an painkillers only, my lord. Because his certification is that she was 98 to 99% burned, my lord. And that is what, my lord, in another judgment, my lord, which I'll be placing before your lordship, is, my lord.
Lordship, he has done his part.
My lord,
and
then, my lord,
today is
let-
kept for
I'll
my
reply if
side.
something is there.
If he
my lord.
makes
Okay,
another
pleasure, lordship.
statement,
Yes, ma'am.
another argument, then it will be
No.
not on my part, your lordship.
She'll make her statement. If in case any reply is required, I'll place, ma'am.
If you are pressing judgment, you place it now.
Yes, ma'am.
After that,
Yes, ma'am. One judgment more I am placing before your lordship is 2019 6 SCC 145. My lord, I'll rely on para 10, my lord. Internal page 3, my lord.
yes.
Well, there cannot be any dispute that a dying declaration can be the sole basis for convicting the accused. However, such a dying declaration should be trustworthy, voluntarily, blamishly, and reliable. In the case the person recording the dying declaration is satisfied that the declarant is in a fit medical condition to make the statement, and if there are no suspicious circumstances, the dying declaration may not be invalid solely on the ground that it was not certified by the doctor. Instances for certification by the doctor is only a rule of prudence to be applied based on the facts and circumstances of the case. The real test is as to whether the dying declaration is truthful and voluntary. It is often said that man will not meet his maker with a lie in his mouth. However, since the declarant who makes a dying declaration cannot be subjected to cross-examination, in order for the dying declaration to be the sole basis for conviction, it should be of such a nature that it inspires the full confidence of the court. So, my lord, this is what I'm placing before your lordship, that, my lord, if that is to be relied, my lord, that has to be trustworthy, voluntary, and it should inspire the full confidence of the court, my lord. Which, to my humble understanding, my lord, this is not there in this particular, my lord, case, my lord. Because the witnesses who are there, my lord, and one of the witnesses was not even present at the, my lord, hospital, my lord, has signed the dying declaration. Thereby, my lord, the dying declaration cannot be, my lord, trusted.
Yes.
This is.
Yes, Bhuyan.
Your Lordship. If I could understand properly the submission made by the parties appearing for the other side, for 3 of the accused persons, my lord. The contention is that material witnesses were not examined. The person who were present during the dying declaration, they were not present at the time when the maker made the dying declaration. And your lordship, my learned friend I.M. Mazumdar, he said that the residence of the accused person situated at the distant place, your lordship. And your lordship, and chain of circumstances are not complete, and there is no enmity. Then your lordship, and the contention of my friend Mr. A. Tiwari is that the person with 99% burn injuries cannot give dying declaration. Mr. Ajit Burman, that is my lord. Ajit is my lord. PW. PW7. He was not present at the time when the deceased made a dying declaration. Husband was not present at the time when the dying declaration was made in the hospital. And the other signatory of the dying declaration, that is PW10, and one Sikha, she was not examined. Your lordship, if I could understand it correctly, these are the submissions made by the counsels appearing for the appellant side. So your lordship, may I take your lordship to the first, the witness PW1, my lord, evidence made by PW1, who has lodged the FIR and who is not a witness, admittedly is not a witness to the dying declaration, my lord. PW1, who is the informant. I am the complainant of this case. I know, lordship, PW1 before oral dying declaration was made. I may be stand corrected. I am the complainant of this case. I know the accused person. The incident took place around 8:30 p.m. on 18/8/18. Hearing a hue and cry in deceased Ruby Pandit's house, I went and saw her so-and-so body burning in the bank of the pond. Taking a gamusa hand-woven towel from Mohan, I covered her private parts. When we asked her, she said that Mohan, Shamoli, and Moni Mujumdar set her ablaze. Ruby is my nobo. When we informed at a police station, police came and took her statement. Later, we took her to Jogizan Hospital as per direction of police. From there, she was referred to GMCH, but she died on the way to hospital. So before PW1, your lordship, oral dying declaration was made by the deceased before her death, my lord. So, lordship, as per evidence of PW1, lordship, the husband of the deceased was not present at the place of occurrence, my lord. May I read the other portion? Second, page 11. Police seized a gallon of kerosene, a burnt bedsheet, assets of burnt clothes, and pieces of plastic sticking on sack from Ruby Pandit's house and took my signature. I lodged the Azahar in the police station on the day of the occurrence itself. Then the cross. I lodged the Azahar as my elder brother was busy in hospital. My elder brother is a carpenter. At the time of the incident, my elder brother was at Hosai. I cannot say when my elder brother went out for his work in the morning. My elder brother and sister-in-law got married about 11 years ago. They had 2 sons. At the time of the incident, both the boys were in my house. The distance between my house and my elder brother's house is about 50 meters. We are 4 brothers. 3 of us live together and Ruby and her husband live separately. We did not hear about any quarrel that had taken place between my elder brother and sister-in-law. On my arrival at the place of occurrence, I met Mohan, Nitendra and Biren Hira. I did not talk with my sister-in-law on the bank of the pond. She said the names of the accused person after she was taken home. At the time, the accused persons were not there, but there were other people. It is not a fact that I had not questioned my sister-in-law and I have adduced false evidence. It is not a fact that the accused had not set a place, but Mohan was present there, Your Lordship. Mohan, another accused person, he was present there. He gave the gamocha and all, you know. Lordship, that the evidence of PW2, Nitendra Bhomik, Lordship, before whom the dying declaration was made, but he was declared hostile, my lord. 161 statement, Your Lordship. May I check the 161 statement once of this Nitendra Bhomik, my lord? Record. Lordship, I'll translate it. It's in vernacular. Statement of Nitendra Bhomik. মোৰ নাম আৰু ঠিকনা ওপৰত কোৱা মতে সত্য মই চেলুন ব্যৱসায় কৰি জীৱিকা নিৰ্বাহ কৰো আজি 18/8/2014 ইংৰাজী তাৰিখে ৰাতিপুৱা বৰষুণ পৰি থকা বাবে মই দোকানলৈ যোৱা নাছিলো ৰাতিপুৱা অনুমান 8:30 মান বজাত so according to him occurrence had taken place at about 8:30 বজাত পথাৰত ঘাঁহ কাটিবলৈ গৈছিলো মাত্ৰ তেনে সময়তে মোৰ ঘৰৰ পশ্চিম ফালে থকা ঘৰৰ মোহন বিশ্বাসে ওচৰৰ পুখুৰীৰ পৰা চিঞৰি চিঞৰি পানীত মানুহ পৰিল বুলি কৈ থকা শুনি মই ওচৰলৈ গৈ দেখা পাও যে পানীত মানুহ এজনী পৰি ককবকাই আছে মই পানীত পৰি থকা মানুহজনী উঠাবলৈ চেষ্টা কৰি থকা সময়তে আমাৰ ওচৰৰে বীৰেন হীৰা আহি মোৰ লগত সহযোগ কৰি মানুহজনী পানীৰ পৰা উঠাই প্ৰথমে চিনি পোৱা নাছিলো কাৰণ মানুহজনী সম্পূৰ্ণৰূপে জ্বলি গৈ গাত কাপোৰ কানি নাছিল পিছত জানিব পাৰিলো শ্ৰী বিজুস পণ্ডিতৰ পত্নী ৰবি পণ্ডিত মানুহজনীৰ গাৰ ছাল স্বয়ংস তেনে সময়তে চিঞৰ বাখৰ শুনি বহুত মানুহ অহাত আৰু জ্বলা মাইকী মানুহজনীৰ দেৱৰ সঞ্জয় আহি পোৱাত সকলোৱে কাপোৰ দি ডাঙি ঘৰলৈ নিয়ে মানুহগৰাকীয়ে চটপটাই জ্বলালে মোক Sameli Mohan Mommy Jolali Buli Theory. So, Lordship, leaving apart the other part, Lordship, the dying declaration, oral dying declaration was made. In his 161 statement, also he has stated, Manu Gorake Sotpotai Jolale, she was shouting that I am burned down by, she has mentioned the name of Sameli Mohan Moni. Pisor Manujoni hospital Louisa. So in 161 statement, although he was declared hostile, my lord, he stated before the IO, wherein he has mentioned the name of accused person, that the deceased was shouting, and in burning condition, she has named the accused person. My lord. Then, your lordship, PW3, Biran, my lord, he has, before whom also, lordship, there is dying declaration, but he was also declared hostile. May I also check once the 162 statement of PW3, my lord?
My lord, these are already translated, my lord, at page 98 and 99, page 100, my lord, to find the 161 statements, my lord.
90.
Page 98, my lord. This is Nitendra Bhomik, page 98, and 99 is Sri Biren Hira, my lord. The statements are there, my lord, in the paper book, my lord.
PW3 Biran, my lord. There also she has mentioned the name of this accused person before PW3. Although he has made another statement before the court, my lord. Before in 161, he has stated, my lord, that the deceased has named the accused person while making the dying declaration. Then, lordship, PW4, who recorded the dying declaration, my lord. May I take your lordship straightway to the dying declaration at my lord, page 84 of the paper book. This is certificate given by the doctor, Your Lordship. And according to him, Ruby Pandit was in a state of, in a conscious state, Your Lordship. Page 84. Certified that I have examined Ruby Pandit, so-and-so, Pijus Pandit on 18/8/14, following police requisition received from IC Jogizan PP and escorted by so-and-so Ojit Burman. He was escorting the deceased. No case number was mentioned under requisition. The following injuries were detected on her person during examination 18/4. I found Ruby Pandit conscious. My lord will kindly note this part. He found the deceased, lordship, the victim who made the dying declaration in a conscious state. Responding to our question, she is almost 98-99% burned. Burn is dead. After going first aid, giving first aid, I have referred the case to GMC immediately. Opinion, grievous injury caused due to burn. Then phase 85. As per police requisition received from IC Jugizan PP under Hojai PS for dying declaration, I, Dr. Khalikus Jaman Chaudhary, SMN HO Jugizan PHC, have recorded the dying declaration of Ruby Pandit, 36 years, wife of Sri Pijus Pandit of Radhanagar PS district, so-and-so 10:30 AM on 18/8/14 in presence of Ojit Burman, Sikha Pandit, Pijus Pandit. Pijus Pandit is a husband. Ojit Burman, the person, my lord PW 7, and another person, another Sikha Pandit, but she was not examined as a witness. So, your lordship, then there are dying declaration. I, Ruby Pandit, want to say on my own will that around 8 AM today, that is on 18/8/14, Shamla Biswas, wife of Mohan Biswas and Moni Mujumdar, daughter of Surya Mujumdar, entered my house and set me on fire by pouring kerosene oil on my person. Later, they told me jump in the pond if I wanted to save myself. Being helpless, I dipped it to the pond. At that time, they called people by shouting that I myself caught fire. Our neighbors lifted me from the pond and took here. They had left the place before the arrival of public. Lordship, there is nothing to disbelieve the dying declaration, my lord. So why should she name the accused person? There is no enmity as such. Because there is a laying of egg is there, as a result of which these persons, your lordship, some controversy, some quarrel had taken place, as a result of which they burned herself down, my lord. And if they won't have present, how they would have known that she has committed suicide or whatever, my lord? They have to be present there in the place of occurrence. If they reside in the distant place, my lord, how do they come to know about that the victim has set her ablaze or whatever, my lord, on her own? Now I take your lordship to the evidence of the doctor who has recorded the dying declaration, my lord. PW4. Page 17. On 18/8/14, while I was working as senior MNHO of Jogizan PHE, on that day, I examined the injured person, Srimati Ruby Pandit, 36-year-old woman. On the basis of police requisition of Jogizan PP, the injured person was identified and escorted by constables Ojit Burman, Jogizan PP during examination. I found Ruby Pandit was responding to our question and she was examined burned having 90 to 99% deep burn injury. So in his substantive evidence also he has stated she was responding. The victim was responding to the question made by the witness, my lord. After giving first aid treatment of Jogizan PHE, I referred the victim to GMCH. As per my opinion, the injuries are grievous in nature caused due to burn. Exhibit 3 is the medical report submitted by, is my signature, so and so. At the time of examination of victim, I also recorded the dying declaration of victim in persons of witnesses as she was found willing to give the statement, as she was also found capable for giving statement declaration. As per her declaration, persons namely Mohan Biswas, Shamala Biswas, and Moni Mujumdar set ablaze her by pouring kerosene by entering into her house at 8 AM on 18/8/14. I obtained the thumb impression of victim on a declaration and I endorse the thumb impression. Exhibit 4 is the said dying declaration of victim Ruby Pandit. 4-1 is my signature along with endorsement note. I first saw the victim at about 10:20 a.m. on 18/8/14. The victim was found on the hospital bed. At the time, the victim was found talking with other person. At the time of recording the dying declaration, the hospital staff and 3 witnesses were present. I questioned the victim. I did not interfere her while she was telling the facts. And the victim could not move her hand, so I helped her put thumb impression on the declaration. I did not sign after endorsing a thumb impression. I don't know, Lordship, this language, not understand. I recorded the dying declaration immediately after admitting the patient in the hospital. Due to critical condition of patient, I referred her to GMCH. It is not the fact that the victim was not in a position to give statement when she was brought to hospital and she was not in a conscious state. It is not the fact that I did not obtain the thumb impression of victim. It is not the fact that the victim did not mention the name of any person in her statement. This is an official witness. Why to disbelieve him, my lord? What personal lordship? He has no personal rivalry against the accused person or whatever, your lordship. Personal interest into the matter is an official witness, my lord. So why he would submit before this honorable court or give evidence before the court below as regards the dying declaration, as regards that the victim was in a conscious state, as regards the victim has named all the accused person, that they have burned herself down, my lord.
Where is this original deposition? Is it on the record?
Lordship, I'll see, I'll check. Of the doctor, my lord?
Yes.
My lord, for a moment, may I please one thing, my lord? At page 85, dying declaration once again, my lord, page 85.
He
You'll
mentioned
get your
of
time, you'll get your time.
Lordship, it's in English. The language is, my lord, his handwriting. Terrible handwriting, my lord. On 18, may I read, my lord? I'll try to read.
No, just come to the cross part.
Cross part, my lord.
That I did not sign or I did not sign up. to
Yes,
the-
yes, I'll
just
check.
take up.
Uh, I did not interfere her while she was telling the facts, as I could not, as she could not move, my lord. Then
As the
thereafter,
witness could move.
I did not, I did that, it's all the same, my lord. I did no sign SIGNED
after record.
after recording the thumb impression, after endorsing the thumb impression. I recorded the dying declaration immediately after admittedly the patient is in the hospital. Lordship, may kindly have a look. Again, huh?
Original is the same, isn't it?
Yes, on this. It's handwritten, but my. Down below, last 3 lines.
What does it mean?
My lord,
I did no sign after endorsing the comment. What does it mean? What does it mean?
that he did not put his signature. May I check the lordship original dying declaration, whether signature is there or not? But it's not, the language is not that clear, your lordship.
That's why we are asking.
I did know signed. But sometimes while a recording, while the witnesses deposits make deposition before the court, sometimes lordship, the court also while writing or the stenographer sometimes do the mistake. May I check the original portion?
Exhibit 4.
Lordship, his signature is there in the original. Senior Medical Health Officer, Jogizan Fuchi. Oh, Lordship, may I clarify one thing? Maybe he is trying to say while the time operation was there, so he should make one endorsement that it's LTI or RTI of the
Yes.
whatever, that is not there. May not be there. I'm not checked.
Yes.
Yes, my lord.
So he's talking about that maybe.
Because that has to be endorsement. If somebody takes a
Lordship, I
operation,
have
my
no
lord, the
judgment.
person who takes, my lord, he is right LTI or RTI of so and so person taken by me, my lord.
Generally,
This is what is done, my lord, generally.
whether it's a serious lapse or whatever, your lordship will decide that. My
But
yes.
in chief, she said so. I obtained the thumb impression of the victim on the endorsed the thumb impression.
Yes. So lordship, may I check that lordship?
Where? No.
Okay.
Endorsement, he has to sign on here again. He has to sign here again. But he did not do.
Vote.
Now the evidence of PW5, my lord. Ratish. Other part is not important. He talks about Mohan. Mohan was present. Mohan was shouting, third line, my lord, at page 20. I heard shouting of Mohan Biswa saying that one person had fallen down in the pond. So Mohan, one of the accused person. And on another aspect, your Lordship will kindly have a look and kindly note it. Page 21, this witness is said at the time her husband was not at home. So Pijus Pandit was not at home. My lord. Page 21. Other part, I don't think it's important, your Lordship. Then PW6 Bikash Sarkar, my lord. Yeah, so this witness talks about presence of Mohan. Mohan was shouting. Third line. On the day of occurrence, accused Mohan Biswa shouted saying that someone had fallen down in the pond. When I rushed to the bank of the pond, I saw a woman lying in the pond. Then Nitendra and Biranita lifted the woman. Then page 23, I heard that the woman told that the accused person had set her on fire. Then, your Lordship, in cross-examination, second line, Pijus had gone out from house about half an hour before the occurrence took place. Then in cross-examination also he reiterated that it is not a fact, the third line from bottom, it is not a fact that the woman had not said anything and that she was not in a state of speaking. Then I take your Lordship to the evidence of PW7, my lord, who is a witness to the dying declaration. Page 24. I know the complainant since after the case. I do not know the accused person. On 18/8/14, when I was working at Jogizan PP, information was received that a woman by name Ruby Pandit was taken to Jogizan Hospital for sustaining burn injury, and I, along with investigating officer Nipon Soikia, went to Jogizan Hospital. I saw the woman there. The doctor recorded the statement of the injured woman in front of me. So he, in his substantive evidence, has stated that he was present when the victim made the dying declaration. I was present. She said the name of accused Moni and two other names of the accused person. She said that they set her on fire. After recording the statement, dying declaration, the doctor took my signature. The villagers took the injured to the hospital. Nipen Soikia and I went to the hospital. The injured was lying on the bed. She had burn injury on her person. I saw burn injury on her face. I saw public. The woman was in a speechless state. I did not understand and what she had said. I did not see whether her husband was present or not. I do not know whether she had mentioned the name of her husband or not. I put my signature when a doctor asked me to do so. I do not know whether the injured put her signature on the dying declaration. So he's a witness to the occurrence or no, to the dying declaration. Now, evidence of PW8 Pijus Pandit, before whom also dying declaration was made, oral dying declaration. Page 26, complainant Sanjay Pandit is my younger brother. This is Ruby Pandit was my wife. I know the accused person. The occurrence took place around 8:30 a.m. on 18/8/14. I went out from my workplace in the morning after taking meal. Then I got the information that my wife's condition was critical and I had to go home. I came home and saw a burn injury on her person. Her whole body was burned. Our co-villagers came and took her to Jogizan Hospital. Police was present in the hospital. When Ruby was asked, she told that at the time of the occurrence, Shamoli was stealing egg. And when she was caught, the accused person came and set my wife on fire by pouring kerosene oil inside her house. And the accused said, if you want to save yourself, jump in the pond. The doctor wrote the said statement and took my signature. Then cross, my wife died on the way to Guwahati. At the time of occurrence, my elder son was 10 years old and my younger son was 8 years old. At the time of occurrence, they were at my younger brother's house. I received the information at 9 o'clock. My helper and I came to my house by riding motorcycle. I found my wife in my house itself. At the time of police also came. The VDP secretary also came. Around 50 people gathered. There were burn injuries on her entire person. She was unable to move. Sanjay Pandit, Sukranjan Pandit, and I took my wife to the hospital. My wife and I did not sit before the police that when Shamoli was going after taking egg, my wife had caught her. It is not a fact that my wife did not give statement in front of me. It is not a fact that I was responsible for setting her on trial. Then the evidence of PW9, man of BDP secretary, Madhusudan Chakraborty. Lordship, page 28. I know the complainant as well as accused. I knew the deceased Ruby Pandit. The occurrence took place one day in the month of August 2014. It was around 8:30 a.m. I was in the shop. At that time, one nephew of Piyush came and informed me that Ruby Pandit caught fire. I went and picked up Ruby from water and laid her on a banana leaf. Police was informed. We took her to the hospital. When police asked to do so, we made police on the road. She died on her way to Guwahati from Jogizan. When a doctor at Jogizan hospital asked, Ruby had said that the 3 accused persons set her on fire. I was the BDP secretary at the time of occurrence. When I went, Ruby was in a state of speaking. Her face was not completely burned. When Ruby was at home, I had not asked her. I cannot say the name of the doctor. It is not a fact that Ruby did not give any statement in the hospital, that she did not say anything, and that she was not in a state to speak anything. It is not a fact that I did not state before police that Ruby had told the names of the accused person in the hospital. It is not a fact that I have adduced false evidence today on being tutored by Piju. Then PW10, my lord, Geeta Devi. She's a witness to the dying declaration. Lordship, page 30. I know the complainant, Sanjay Pandit, from the day of occurrence. I do not know the accused person. On 18/8/14, while I was working as GNM nurse at Jogizan PG, a woman with burn injury was taken to the hospital, which resulted in much activity in the hospital. Dr. K.J. Chaudhary was on duty, so I informed him the name of the woman was Ruby Pandit. Police came to the hospital as the condition of the patient was critical, so Chaudhary sir referred her to Guwahati. Chaudhary sir recorded a statement of the woman. I was present there. My signature was taken as a witness of the statement. Exhibit 4 is the statement. Exhibit 44 is my signature therein as a witness. When the statement was taken, Ruby Pandit was in a state of speaking. She stated that 2-3 persons entered in her house and set her on fire by pouring kerosene oil. Her face was burned, not burned. The remaining part of her person was burned. The injured was from Bengali community. When Dr. Chaudhary asked, she was saying her utterance were intelligible. I cannot say who did write her statement. I put my signature after writing. I have forgotten who did tell me to put my signature. I did not notice who did her thumb impression. It is not a fact that the statement was not written as per Ruby's version. Then, my lord, PW 11. I owe your lordship. Page 32. On 18/8/14, I was working as in charge at Jogizan PP. On that day, informant Sanjay Pandit lodged an Azahar against the accused Mohan, Chameli, and Moni Mojumdar about burning Ruby Pandit, the wife of his brother, by accused. After receiving the FIR, I made a GD entry by PP, GD entry number 309 dated 18/8/14 at 4 p.m. and forwarded the OC Hosai to register a case. Lordship, here there are 2 GD entries, my lord. One, some information was earlier given regarding the occurrence. There are 2 GD entries I have checked, my lord. GD number 309, 18/8/14 at 4 p.m. wherein this witnesses have deposed. And GD number 304 dated 18/8/14 by ASI Suborna Das, my lord. There are 2 GDs. So, your lordship, I made a GD entry by Jogizan PP GD entry number 309 dated 18/8 at 4 p.m. and forwarded to OC Hosai to register the case. Accordingly, the said case was registered as Hosai PS case number 400/14 and I was endorsed to investigate the case. I recorded a statement of the informant. ASI Suborna Kumar Das, before filing the FIR, he made another GD entry number 304 dated 18/8/14. after getting verbal information regarding the occurrence, and he visited the place of occurrence and sent the victim to Jugidan PHE. And he also recorded a dying declaration of the victim by doctor and sent the victim to ZMCH for better treatment. He also recorded a statement of few witnesses and he brought the accused person to Hojai PS. I interrogated the accused Shamoli, Mohan and Champa Muzumdar, alias Moni, and recorded their statement. Accused Shamoli Biswas has confessed the guilt during the time of examination. I forwarded all the accused to jail custody. I collect the dying declaration of the victim. On 19/8/14, I got the information about the death of victim Ruby Pandit at Guwahati. I recorded a statement of witnesses, namely Piyush Pandit, Sikha Pandit, UGC Ajit Burman, and GNM Gita Devi, who were present at the time of dying declaration of the victim. I collected a copy of dying declaration as well as a post-mortem report. After completion of investigation, I filed a charge sheet against the accused person under section so-and-so. Then is a 161 statement of the accused Shamoli Biswas. I also collected the inquest report of GMCH. Then at page 33, cross-examination part, the day of occurrence is on 18/8/14. On that day, I was busy with another case. For that reason, ASI Subarna Das went to the place of occurrence for doing the investigation. At that time, I was not present at PS. GG entry was made by GD entry number 304 dated 18/8/14 by ASI Subarna Das. He visited the place of occurrence, took the injured person to Jogijan Hospital, and the victim was referred to ZMCH Guwahati for better treatment. And a dying declaration of the victim, etc., had been done in the Jogijan Hospital by the ASI Subarna Das. I did not visit the place of occurrence. After referring the victim to Guwahati, the FIR was lodged at 5 p.m. on 18/8/14. The statement of the informant Sanjay was recorded by me. Informant is the brother of the husband of the deceased. At the time of recording the dying declaration, I was not present there. On 2/10/14, I have recorded the statement of Piyush Pandit, the husband of the deceased. I cannot say when the husband of the deceased Piyush Pandit went out from his house. I have not written anything regarding the dispute between the husband and wife. I have submitted the charge sheet basing on the investigation by ASI Subarna Das and partly of my own. The burn was committed inside the house of the husband Piyush Pandit. At the time of committing burning, the husband was outside from the house and also the children were not in the house somewhere else. It is not a fact that I have submitted the charge sheet on mere suspicion. Then the evidence of other IO, my lord, at page 34. On 18/8/14, I was working as ASI at Jogijan PP. On that day at 9:30 a.m., one BDP secretary of Radhanagar, Madhu Chakraborty, informed over phone that a lady was set fire by two women by pouring kerosene, due to which she was totally burned and in critical condition. Accordingly, I made a GD entry by Jogijan PP GD entry number so-and-so dated 18/8/14. I informed the matter. So this GD was made at 9:30, my lord, immediately after the occurrence on a telephonic information received from VDP secretary. Accordingly, I made a GD entry by Jogijan PP GD entry number 304 dated 18/8/14 and informed the matter to higher officer, and I proceeded to the place of occurrence along with the staff. I proceeded to the place of occurrence as the in charge of the Jogijan PP went to the SP office Nagaon for official purpose on that day. On that day at about 10 a.m., I arrived at the place of occurrence and found that the victim Ruby Pandit was in a critical condition. I arranged to send the victim to Jogijan PHE for her treatment. I also prayed the doctor of Jogijan PHE to record a dying declaration of the victim, as the victim was in very critical condition. Thereafter, I again appeared at the PO at 11 a.m. and I draw a rough sketch map of the PO and seized some articles like a gallon of kerosene, a bedsheet partially burned, etc. I prepared a seizure list after seizing the articles in presence of witness available there. I also record a statement of some witness, namely Debashish Roy, Moni Pandit, and Sanjay Pandit, which were seizure witnesses. I also recorded the statement of witness Nitendra Vomik, Biren Hira, Totis Sarkar, Bikas Sarkar, Madhu Chakraborty, Gautam Chakraborty. I searched the house of suspected accused to arrest them. In the meantime, I came to know that the arrested accused Shamoli, Moni, Mohan were detained by local public when they were tried to flee away. Lordship, having come to know about it, they have flown away. This is a conduct your Lordship will kindly have look and note it, madam. After getting the information, I, along with Lady Constable, apprehended them and I sent them to Hosai PS for preliminary interrogation. In the meantime, I was informed by the victim's relatives that the victim was taken to ZMCH and she died there. Immediately, I sent the WT message to OC Bhangagar PS to conduct the PM by doctor. On the same day, an FI was lodged and the same was forwarded to OC Hosai PS by IC Jugijan PP and the same was handed over to IC Nipan Saikia to investigate the case for further investigation. I handed over my CD to IC Jugizan PP. I recorded a statement of the witness, Niran Bhomik, and in his statement, he stated before me that the victim was making outcry by shouting that Jolale Jolale by Shamoli, Mohan, and Moni. I also recorded a statement of so-and-so Biren Hira. He has stated before me that after recovery of victim from water, she was screaming that Mohan, Shamoli, and Moni burnt her. The said witnesses also stated before me that after the occurrence, people gathered there. The accused Mohan, Shamoli, and Moni fled away from their house. Exhibit 6 is the CD and so-and-so is a 161 statement of the witness Nitendra Bhomik recorded by me. Exhibit 66 is my signature. So-and-so is a 161 statement of Biren Hira recorded by me. Then, my lord, the cross portion. The day of occurrence took place at about 9:30 a.m. and the in charge of Jugizan PP was returned at 4:45 p.m. from SP office. I have taken necessary step of the case in between 9:30 a.m. to 4:45 p.m. I found the injured person inside the auto rickshaw in front of the house of the deceased on the road at a distance of 100 to 150 meters from the house of the deceased. The injured was taken to Jugizan PHE and I also went there. 2 constables were with me, namely Deepak and Ojit. So he named Ojit Bormon, Lordship, that this Ojit Bormon, he accompanied this IO minor. It is not a fact that witness Nitendra Bhomik stated before me as Jolale, Jolale, Muk, Shamoli, Mohan, and Moni. It is not a fact that the witness Biren Hira did not state before me. After recovery of the victim from water, she was screaming that accused Mohan, Shamoli, and Moni burnt her. The informant of this case, Sanjay Pandit, the husband of the deceased, when went out from his house, I cannot say. I have not mentioned in my diary at the time he went away. Sanjay Pandit had 3-4 children. I have not mentioned anything regarding the minor children of the deceased. I have recorded only the statement of witness Nitendra Bhomik, Birendra Hira, Roti Sarkar, Vikas Sarkar, Madhu Chakraborty, Gautam Sutradhar, Sanjay Pandit. I cannot say the statement of the witness recorded by me, where also recorded the IO of this case. It is not a fact that any dying declaration victim was recorded in my presence. It is not a fact that the deceased victim did not state the name of the accused person. The husband of the deceased was not present at the time of treatment given the hospital at Jogizan. Direct from Jogizan PHE, the victim was referred to CMC Guwahati. It is not a fact that I have not investigated the case properly. That PW13 is the medical officer who done the autopsy, my lord. Now, I take your lordship to the 313 statement of the accused person. Except Mohan, other witnesses, lordship, the total denial, but Mohan, my lord, page 43 will, lordship will kindly have a look. In 313 statement. Answer to question number 1. I am innocent. It is a fact that after coming from Paddyfield, I saw the victim in burnt condition. And from my head, Sanjay took my gamocha and covered for her private parts. Lordship, other accused person do not give any explanation. Lordship, accept the denial, my lord. Only this person says, and some of the witnesses also deposed the presence of Mohan. So your lordship will kindly judge that part. whether he was shouting after the occurrence, but your lordship believes the dying declaration part, then he is an accused of the occurrence. But in 313, he said that he was in a paddy field, hearing the lordship's scream and sound, he came there, and from him, Gamucha was taken. Now I take your lordship to the sketch map, my lord, page 104. Place of occurrence is A, my lord, indicates the place of occurrence at the house of the victim. And your lordship will see house of this accused person, Mohan Biswas, Samoli Biswas, B is your lordship. In sketch map, just nearby, 20-30 meters away from the place of occurrence in the north. And the house of other accused person, C, Champa. Her house is also situated at a distance of 15-20 meters. C, my lord. And the pond, D, my lord, where the victim was not drawn, your lordship. After the burning, she went there and lordship, as per the version of the accused person, she dipped herself there. It's a D, my lord, pond. So, lordship, in the case in hand, all rest into one part, the dying declaration. Whether if the dying declaration is believable, then your lordship will convict the accused person. If your lordship, it's not believable, then they might, I leave it to your lordship, they might get some benefit. So your lordship, may I take your lordship to the citation, whether in 80%, 90% burn, whether a person can be in a conscious state, what will be the state of mind, my lord? And if there is any irregularity here and there, whether it should be avoided at a stage or whether your lordship will kindly take into account. First, regarding your lordship, non-examination of the material witnesses, may I give citation? 2013, 6 SCC 428. Para 16, 17, and 22. Lordship, para 16. Page 429, my lord, the 3 PWs were given up by the prosecution as having been won over, had been cross-examined by the defense. In view of this position, it cannot be said that the defense of the accused has suffered any prejudice as a result of non-examination of these 3 witnesses. Lordship, here, but 16, 17, and 22, page 429 of the Yanov Sheikh judgment, my lord.
Huh?
Just second page of the judgment, second page. Second page, down below.
Read from the original.
Yes, my lord. Para 16, it's a long paragraph, your lordship. page 246.
Yes.
246, my
Are we on the right track?
Lordship, because references given to certain judgments, all paragraphs are given there. Page 446 of the judgment, my lord.
446.
Yes. Para 16. Has the lordship got it?
Yes.
Yes. The next contention raised on behalf of the appellant that we are to deal with is that the prosecution should have examined all witnesses without exception. The fact that the prosecution failed to examine PW8, PW9, and PW10 itself renders the prosecution story feeble. It is correct that in the present case, PW8, PW9, and PW10 were produced as witnesses before the court. After recording the introductory part in the examination chief, the prosecution gave up these witnesses as having been won over and tendered them for cross-examination. The court, in its order dated 3/7/1992, recorded this aspect and also mentioned that the witnesses had been cross-examined by the defense. In view of this opposition, it cannot be said that the defense of the accused was suffered by prejudice as a result of non-examination of 3 witnesses. It is, lordship, please, para 17 in, may I see what, para 17. It is interesting to note that PW8 Yamin in his cross-examination admitted that he was examined by the investigating officer and also that he had stated before the Daroga Babu that on the date of the incident since morning, he was drawing water from Baroloria Pukur through a pump set taken on hire from Humayun Kabir, PW7. No further questions were put to him, put this witness by the accused. Whatever he stated in his cross-examination to some extent supports the case of the prosecution. It proves that the incident occurred on that day. Pump was taken on hire and people of the village during the day were drawing water from the Baroloria Pukur. It is thus clear that non-examination of these witnesses has neither prejudiced the case of the prosecution, nor will it be of any serious advantage to the accused. For this purpose, reliance has been placed upon a judgment of this court in Masalti versus State of UP, where the court held it is undoubtedly the duty of the prosecution to lay before the court all material evidence available to it, which is necessary for unfolding this case. In Masalti, the judgment relied upon by the learned court, counsel for the appellant, this court, while making it clear the duty lies upon the prosecution to examine all material witnesses, clearly stated the situation where the witnesses may not be examined because they have been won over, terrorized, and they may not speak the truth before the court. The court in para 12 held as under. In the present case, however, we are satisfied that there is no substance in the contention which Mr. Sahni seeks to raise before us. It is not unknown that where serious offenses like the present are committed and a large number of accused persons are tried, attempts are made either to terrorize or win over prosecution witnesses. And if the prosecutor honestly and bona fide believes that some of the witnesses have been won over, it would be unreasonable to insist that he must tender such witnesses before the court. It is undoubtedly the duty of the prosecution to lay before the court all material witnesses, evidences available to it, which is necessary for unfolding this case. But it would be unsound to lay down as a general rule that every witness must be examined even though his evidence may not be very material or even if it is known that he has been won over by the terrorized. In such a case, it is always open to the defense to examine such witnesses as their witnesses, and the court can also call such witnesses in the box in the interest of justice under section 540 CRPC. As we have already seen, the defense did not examine these witnesses, and the court, after due deliberation, refused to exercise power under so and so. That is one aspect of the matter which we have to take into account. But in our case, my lord, only one Sikha, she was not examined. Other material persons are examined, your lordship. Then para 22, my lord. The facts of the present case, seen in light of the above principle, make it clear that the court is primarily concerned and has to satisfy itself with regard to the evidence being reliable, trustworthy, and of a definite evidentiary value in accordance with law. PW 1, 5, and 6 have clearly supported the case of the prosecution. The statements examined in conjunction with the statements of PW 11 The doctor and the investigating officer in PW 14 clearly established the case of the prosecution beyond any reasonable doubt. Then, your lordship, another judgment on material witness, my lord. 2007-15 SCC. 393. Para 19, madam. Para 19, page 397. Next contention of the learned counsel for the appellant that adverse inference should be drawn against the prosecution for non-examination of the informant and other material witnesses does not merit acceptance. In the teeth of the reliable and convincing evidence which is come on record, we have no other option but to accept the finding recorded and the conclusion arrived at by the High Court on reappraisal of the entire evidence on record to hold that it was the appellant and none else who has committed the murder of Dilip. The prosecution has been able to establish the offense against the appellant beyond also and so. So, lordship, in para 19, they had said whether it's fatal or not. In our case, my contention is that my respectful submission is that it's not fatal to the prosecution. Now, your lordship. Regarding the dying declaration, my lord. Not 90% burn injury, your lordship, where the Honorable Supreme Court made some certain observation. 2005 10 SCC 737. Lordship has got it, my lord. Para 14. Shri Vijay Kumar Nanada was a state of Inspector of Police Kanyakumari.
Yes.
Here, in this case, your lordship, 90% burn was on the victim, your lordship. The dying, para 14, the dying declaration recorded by the judicial magistrate cannot be assailed on any German ground. We cannot accept the contention of the learned counsel for the appellants that the deceased would not have been in a position to sustain his consciousness and give a statement narrating the details of the incident. The evidence of the magistrate PW2 is unequivocal that the deceased was conscious and was able to answer the questions. The certificate of the doctor who was with him was also obtained on the dying declaration. If some persons other than the accused attacked or burned him, there is no reason why the deceased should have thought of implicating the accused while leaving out the real culprits. So, your lordship, in this case, your lordship, Honorable Court hold that a 90% burn injury, when the doctor gives the certification that the doctor gives the statement, your lordship, that she was in a conscious state of mind, there's nothing to disbelieve, your lordship, because here, in our case also, this is an endorsement made by the doctor. The signature is there, his seal is there, your lordship.
Yes.
And in this case, 2002, 8 SCC 83, the victim suffered from 85% burn injury, madam. Another citation I'm placing before your lordship.
2000.
2002, 8 SCC 83. In this case, the victim suffered from 85% burn injury, Your Lordship, para 6 of the judgment. Page 85.
Yes.
So far as the position of law in regard to the admissibility of the dying declaration, which is not certified by the doctor, the same is now settled by a constitution bench judgment of this court reported in Lakshman for the state of Maharashtra, wherein overruling the statement of this court in Lakshmi versus Om Prakash is held that a dying declaration which does not contain a certificate of the doctor cannot be rejected on that sole ground, so long as the person recording the dying declaration was aware of the fact that as of the condition of the declarant to make such dying declaration, if the person recording such dying declaration is satisfied that the declarant is in a fit mental condition to make the dying declaration, then such dying declaration will not be invalid solely on the ground that the same is not certified by the doctor as to the condition of the declarant to make the dying declaration. Be it as it may, so far as this case is concerned, that question does not arise because in the instant case, PW9, Dr. Ashok Sharma, though not a doctor who treated the deceased, but being the duty doctor when someone came and examined the deceased and noted in the dying declaration itself as to the capacity of the deceased to make a dying declaration, that apart from the narration of the question and answers in the dying declaration, it is clear that the deceased was in a fit state of mind to make the statement. But the learned counsel for the appellant contended that we should examine the contents of the dying declaration in the background of the fact that the deceased had suffered nearly 85% burns, and ever since his admission into the hospital, she was altering between consciousness and unconsciousness, as also earlier attempts to record her dying declaration had failed. Therefore, the learned counsel contends that it is not safe to place reliance on the dying declaration. We have carefully perused the evidence of PWs 12 and 11, who recorded the dying declaration, and PW 19, who is the doctor who certified the condition of Vidya Bai. From their evidence, we are satisfied that the deceased at the time she made the dying declaration was in a fit condition of mind to make such statement. Having found no discrepancy in the statement of the deceased, we are inclined to accept the same as held by the courts below. Learned court then contended that from the evidence of the husband DW2 himself, it is clear that the deceased must have suffered burn injuries while she was cooking lunch. Therefore, it is not safe to rely upon the prosecution evidence to convict the appellant. We notice the courts below have considered this argument and taking the preponderance and evidence and also the factum that the husband of the deceased had resigned from a statement made before the investigating officer have held it is not safe to rely on DW2. In such a situation, we are unable to take the contra view from the one taken by the courts below. I'm making this submission, referring the judgment on the point that with 80% burn, 85% burn, Lordship, it's up to the doctor to certify. If the doctor certifies it regarding the mental state of the deceased, my lord, the victim, then your Lordship may take into account the dying declaration. Lordship, one more judgments on dying declaration, my lord, 2005 9 SSC 113. Para 13, 14, and 18. para 13 and page 119.
Yes.
At this juncture, it is relevant to take note of Section 32 of the Indian Evidence Act 1872, which deals with cases in which statements of relevant fact by a person whose date or cannot be found, etc. is relevant. The general rule is that all oral evidence must be direct. That is, if it refers to a fact which could be seen, it must be the evidence of the witness who says he saw it. If it refers to a fact which could be heard, it must be the evidence of the witness who says he heard it. If it refers to a fact which could be perceived by any other sense, it must be the evidence of the witness who says he perceived it by that sense. Similar is the case with opinion. These aspects are elaborated in Section 60. The 8 clauses of Section 32 are exception to the general rule against hearsay just stated. Clause 1 of Section 32 makes relevant what is generally described as dying declaration, though such an exception has not been used in any statute. It essentially means statements made by a person as to the cause of his death or as to the circumstances of the transaction resulting in his death. The grounds of admissions are, firstly, necessity for the victim being generally the only principal eyewitness to the crime. The exclusion of the statement might deflect the ends of justice. And secondly, the sense of impending death, which creates a sanction equal to the obligation of an oath. The general principle on which this basis of evidence is admitted is that they are declarations made in extremity, when the party is at the point of death and when every hope of this world is gone. Your Lordship will kindly note that part. When every motive is pursued is silenced, and the mind is induced by the most powerful considerations to speak the truth. A situation so solemn and so lawful is considered by the law as creating an obligation equal to that which is imposed by a positive oath administered in a court of justice. These aspects have been eloquently stated by Iyer LCB in R versus Woodcock. Shakespeare makes the wounded Melum, finding himself disbelieved while announcing the intended treachery of the Dauphin Livy, explained. Have I made hideous death within my view, retaining but a quantity of life, which bleeds away even as a form of wax? Lordship then resolved. So this paragraph of Shakespeare was quoted, my lord. The principle on which dying declaration is admitted in evidence is indicated in the legal maxim, nemo moriturus presumeter menter. A man will not meet his maker with a lie in his mouth. Then, your lordship, para 14. This is a case where the basis of conviction on an accused is a dying declaration. The situation in which a person is under deathbed is so solemn and serene when he is dying that the grave position in which he is placed is a reason in law to accept veracity of his statement. It is for this reason that the requirements of oath and cross-examinations are dispensed with. Besides, should the dying declaration be excluded, it will result in miscarriage of justice because the victim being generally the only eyewitness is a serious crime. The exclusion of the statement would leave the court without a scrap of evidence. Then para 18, my lord. Then may I read para 15 also? Though a dying declaration is entitled to great weight, it is worthwhile to note that the accused has no power to cross-examination. Such a power is essential for eliciting the truth as an obligation of oath could be. This is the reason the court also insists that the dying declaration should be of such a nature as to inspire full confidence of the court in its correctness. The court has to be on guard that the statement of the deceased was not as a result of either tutoring or prompting or a product of imagination. The court must be further satisfied that the deceased was in a fit state of mind after a clear opportunity to observe and identify the assailant. Once the court is satisfied that the declaration was true and voluntary, undoubtedly it can base its conviction without any further corroboration. It cannot be laid down as an absolute rule of law that a dying declaration cannot form the sole basis of conviction unless it is corroborated. Rule requiring corroboration is merely a rule of prudence. This court has laid down in several judgments the principles of governing dying declaration. which could be summed up as indicated in Paniben versus State of Gujarat. There is neither rule of law nor of prudence that dying declaration cannot be acted upon without corroboration. If the court is satisfied that the dying declaration is true and voluntary, it can base conviction on it without corroboration. The court has to scrutinize the dying declaration carefully and must ensure that the declaration is not the result of tutoring, prompting, or imagination. The deceased had an opportunity to observe and identify the assailant and was in a fit state to make this declaration. But a dying declaration is suspicious. It should not be acted upon without corroborative evidence. But a deceased was unconscious and could never make any dying declaration. The evidence with regard to it is to be rejected. A dying declaration which suffers from infirmity cannot form the basis of conviction. Merely because the dying declaration does not contain the details as to the occurrence, it is not to be rejected. Equally, merely because it is a brief statement, it is not to be discarded. On the contrary, the shortness of the statement itself guarantees truth. Normally, the court, in order to satisfy whether deceased was in a fit mental condition to make the dying declaration, look up to the medical opinion. But where the eyewitnesses say that the deceased was in a fit and conscious state to make the dying declaration, the medical opinion cannot prevail. Where the prosecution version differs from the version as given in the dying declaration, the said declaration cannot be acted upon. Where there are more than one statement in the nature of dying declaration, one first in point of time must be preferred. Of course, if the plurality of dying declaration could be held to be trustworthy and reliable, it has to be accepted. Then, my lord, para 18. It was observed by Constitution Bench of this court in Lakshman versus State of Maharashtra that where the medical certificate indicated that the patient was conscious, it could not be correct to say that there was no certification as to the state of mind of the declarant. Moreover, state of mind was proved by testimony of the doctor who was present when the dying declaration was recorded. In the aforesaid background, it cannot be said that there was any infirmity. Further, if the person recording a dying declaration is satisfied that the declarant is in a fit medical condition to make a dying declaration, then such a dying declaration will not be invalid solely on the ground that the doctor has not certified as to the condition of the declarant to make a dying declaration. In the instant case, contrary to what the accused plead, the doctor's certificate is there. Lordship, then one more judgment and dying declaration regarding thumb impression part. 2004 10 SCC minor 776. Para 4 and 6. Para 4, my lord. Mr. M. and Krishnamani, learned senior counsel appearing to support the appeal, firstly submitted that at the foot of the dying declaration, the doctor has simply given a certificate that the victim was conscious and he has nowhere stated that he was in a fit state of mind. Therefore, no reliance can be placed upon the dying declaration. In support of this submission, learned senior counsel has placed reliance upon the decision of this court in Papadambaka Rosamma versus State of AP. On the other hand, learned counsel appearing on behalf of the state pointed out that the learned senior counsel for the appellant has cited a decision which has been overruled by the Constitution Bench of this court in the case of Lakshman versus State of Maharashtra. We do not find any force in submission of the learned senior counsel appearing for the appellant for two reasons. Firstly, the Constitution Bench is specifically stated in para 5 of the judgment that for the reason already indicated earlier, we have no hesitation in coming to the conclusion that the observation of this court in so and so to the effect that in the absence of medical certification that the injured was in a fit state of mind at the time of making the declaration, it would be very much risky to accept the subjective satisfaction to magistrate who opined that the injured were in a fit state of mind at the time of making the declaration has been too broadly stated is not the correct enunciation of law. This shows the judgment rendered by three judge bench has been overruled by the decisions of the Constitution bench. Secondly, even a three judges bench judgment of this court in the case of Paparamba Rosamma does not help the appellant, as in that case in dying declaration as well as in the evidence in court. The doctor simply said that the patient was conscious, but nowhere mentioned the mental condition of the victim. In the present case, the Dr. PW7 specifically stated the court that prior to recording of the dying declaration, the magistrate asked him as to whether the patient was in a conscious state and if he could answer the questions put to him. The witness says that he told the judicial magistrate that the victim was fully conscious and he was in the state of answering the questions put to him. This being the position on both the grounds, we do not find any substance in the first submission of learned senior counsel appearing on behalf of the appellant. And para 5, learned senior counsel further submitted the dying declaration was recorded by the judicial magistrate on the date of occurrence itself at 3:35 p.m. when the names of all the 4 accused persons were sent up for trial in the present case were enumerated. Whereas in the first information report, which was lost on the next day at 9:30 a.m., names of the 2 appellants were mentioned and names of other accused persons not disclosed. In other view, this was a point which could have been relevant for considering conviction of the other accused person. But since they have been already acquitted, it is not necessary for us to go into the same. The appellants cannot take advantage of the fact that the names of other accused were not enumerated in the first information report. So far as they are concerned, their names were very much there in the dying declaration as well as in the first information report, and recording of dying declaration has been supported by judicial magistrate so and so. Learned senior counsel then submitted that the victim was a literate person, and there was no reason why the judicial magistrate failed to take his signature and had taken only left thumb impression. We do not think that on this ground veracity of recording of dying declaration can be doubted in any manner. In our case also, thumb impression was given. Lordship, last judgment and dying declaration. Two 2005-12 SCC 287. Para 3. Para 3 and para 4.
Yes.
Learned senior counsel for the appellants tried to challenge the first dying declaration. Here, 2 dying declarations are there. Mainly that there was no proper certification about the fitness of the maker of the declarant the relevant time. It was stated that a doctor who gave the certificate was not the treating doctor of the lady, nor was there any entry made in the bedhead ticket about the certificate issued. Both these points do not appeal to us. The dying declaration shows clarity of mind of the maker of the declaration. We have no reason to doubt the certificate issued by a qualified doctor about the fitness of a maker of the statement at the relevant time. Nothing has been asked to suggest that the doctor was in any way interested in the outcome of the case, Your Lordship. And kindly note that part. Nothing has been asked to suggest that the doctor was in any way interested in the outcome of the case. It is not necessary that only a treating doctor must certify fitness for making the statement. Secondly, it was argued by the learned counsel for the appellants that in a dying declaration, it has been stated that the reason for the crime was demand for dowry, which could not be made up by the family of the deceased. The accused have been acquitted of the charges under section 498A. Therefore, according to the learned counsel, it cannot be said that the present was a case of harassment of the lady on account of dowry. We are unable to accept this contention of the learned counsel. The prosecution was not able to sustain the charge under 498 IPC, for its standard of proof required is high. The allegation of Dinesh Kumari about she being harassed on account of demand for dowry cannot be ignored. Moreover, the dying declaration was made much before the verdict of acquittal in such and so and so. Then your lordship, para 4. About the second dying declaration, it is argued that Dr. Sham, who has certified as fit, the maker of the dying declaration had not been examined, therefore, so installation may not be relevant because in our case, doctor who before whom the dying declaration was made was added as a witness, your lordship. So taking into account the entire evidence on record, your lordship, because of laying of or stealing of egg, the occurrence had taken place. Lordship, this accused person came to the residence of the victim, my lord, and they have set her ablaze, your lordship. And thereafter they have tried to flee from the scene, my lord. Although one of the accused person, Mohan Biswas, he was shouted. Your lordship may take either of the views, whether seeing the thing he shouted or lordship to give away, lordship to avoid that he was not the perpetrator. He did that scene, your lordship. And there is no lordship in 313 statement. No plea was taken, your lordship, that hearing hue and cry, they came there, lordship, and they were not at the place of occurrence. There was only denial, my lord. Only the accused Mohan said that he came hearing the hue and cry, man. In 313 statement, he took the plea. So, lordship, if your lordship takes into account the sketch map also, the residence of the accused person are situated in the vicinity, close vicinity, lordship. So there's a possibility that the story narrated by the victim, well, there is nothing to disbelieve, my lord. She has not taken the plea before her death that there was earlier enmity was there or something like that, my lord. Only due to laying of egg, these persons came and they did the quarrel, your lordship. They fought with the victim and they set her on fire, your lordship. There's nothing to disbelieve, my lord. And your lordship, my contention is a learned court below has rightly convicted this two accused appearance. The chain is complete, your lordship. Dying declaration, nothing to disbelieve. And all formalities are done while recording the dying declaration, my lord. The relevant witnesses were examined, my lord, and they have deposed that they have before whom, some of the witnesses before whom the oral dying declarations were made, some of the witnesses before whom they have, they say that the dying declaration is made, doctors endorse the signature, the dying declaration, and they put their signature as witness. It's there on record, my lord. So your lordship, my respectful submission is that your lordship will appeal the judgment of the learned court.
My lord, to reply my learned senior counsel's query, my lord, first of all, I'll take your lordship to PW1. PW1 says that he's the informant, my lord. He says that he took the gamucha from this Mohan, my lord. So at page 10, my lord, line number 4, my lord. So the gamucha part is there, Mohan was there, my lord. He has seen, so he shouted, my lord. So he wanted certain people to be there. First part. But my lord, this PW1 says that before police and doctor, the victim made these statements. But Nitendra, Birendra, those two were, my lord, the persons who were declared hostiles, my lord. So their 161 will not do anything, my lord. Because the statements which are given in the court of law are taken as evidence, my lord.
I mean,
If they differ, my lord, because my lord, 161 are generally for contradiction, my lord.
no,
Those cannot be brought for corroborating certain aspects. First part, well, since my learned senior counsel has already completed, my lord.
I may be wrong, my lord, but he should not make any wrong submission before this court. Hostile evidentiary value, hostile, it is still subsists, your lordship, when it is lordship supported by other independent witness. It cannot be thrown out the threshold, my lord.
Well, that is what I'm trying to place from the record, my lord. Now, this, even if I take the submissions of my learned senior colleague, my lord, last part, my lord, of page 11, my lord, the hostile witnesses says, accused Mohan pointed out to the pond and said someone was there. Now he is corroborating that part, my lord. The other witnesses also saying, even the informant, my lord, he says that, yes, I took gamcha from Mohan and thereafter. The other witnesses also saying that Mohan shouted, my lord. So, my lord, there is nothing to place. Even, my lord, the cross done by the prosecution, my lord, He has denied the suggestion while he was declared hostile. It is not a fact. I stated before the police after lifting from water. The woman had told Square Mohan Sharma and Moni set on fire. So he denies the suggestion at page 14, my lord. So my lord, 161, my lord, I am not signing. A witness is not signing to 161, my lord. That is what, my lord. That can only be taken care of by in the defense to contradict what I stated in the 161, my lord. My lord, because 161, my lord, if the witness one comes to the court, my lord, he is under 164. Even a statement recorded under 164 before a magistrate, thereafter, if the magistrate comes and deposes the court, my lord, that 164 becomes a 161 statement in the court, my lord. Because afresh the witness is making statement before the court of law, my lord. But there are witnesses in the trial court, my lord. Each day, my lord, I'm doing cross-examination. They say, police did not even examine me. Then, man, where will the 161 goes, my lord? That is what, my lord, a witness. Otherwise, my lord, if the investigation officer would taken the witnesses, the person can be convicted. There is no requirement of cross-examination, my lord, and fresh deposition in a court of law, my lord. So that is why, my lord, the witnesses are brought. Now, my lord, the 3 has also been given hostile. But page 15 says that Mohan made a hue and cry saying that someone falling down in the water. So he corroborates the statement of the informant, my lord. That Mohan was there. He was shouting, hearing his scream. Now this witness also says that Nitendra and I went to the pond. Now, my lord, the informant in his evidence, the most important part, what he says that the lady, the victim, my lord, did not state anything near the pond. When she was brought inside the house, she gave the statement that so-and-so has set her ablaze. But this oral dying declaration is nowhere as an evidence brought by the prosecution before the court that on the basis of that oral dying declaration, the accused person should be convicted. That is not the case, my lord. Here, a dying declaration which was recorded in the hospital, my lord, is the sole document whereby the accused persons are being convicted, my lord. Now, my lord, I'll just take your lordship to the other witnesses who corroborated the statement of 2 and 3, my lord. This is PW6, my lord. Kindly see. PW6, page 22, my lord. Page 22, my lord. Third line. Mohan Biswas shouted saying that someone has fallen down in the pond. When I rushed to the bank of the pond, I saw the woman lying in the pond. Then Nitendra and Virendra, now this 2 and 3, PW 2 and 3, lifted the woman. So very same statement is there, but he never says that she said about those things, my lord. Jolele, jolele. He did not say. Now, my lord, in the cross part, my lord, see line about 4th, my lord. In the cross part, page 23, the woman was in an unconscious state when she was lifted from water. Now, my lord, I'll just take a lordship to PW5 once again, my lord. The other person, my lord, who says the very same message, page 20, my lord. Kindly see. He is also an independent witness who was near the pond, my lord. My line about 3, my lord, page 20. I heard shouting of Mohan Biswas saying that one person has fallen down in the pond. I arrived at the bank of the pond, but in the meantime, Nitendra and Virendra lifted the woman. So he corroborates the statement of 2 and 3. He was wrongly declared as hostile by the landed court below, my lord. He should not have been, because the other independent. Now, my lord, in the cross part, page 21, first line, my lord. This PW5 says, the woman was not in a state of speaking. Now, my lord, the most important part, while I'll place before your lordship, my lord, page 84, the certificate of the doctor, my lord. Once again, who recorded the dying declaration. Page 84, my lord. Most important part missing in the certificate is that I recorded the dying declaration, my lord. This is not there. Certified that I examined Ruby Pandit, so and so on 18th following police requisition received from so and so, escorted by Ajit Barban. No case number was mentioned on the requisition. The following injuries were detected on a person during examination. I found so and so conscious responding to our questions. She is almost 98 to 99%. Burn is deep. After going first aids, I referred the case to medical GMC hospital, so and so. So, my lord, nowhere this doctor states that I took the dying declaration. Now, The other most important part, page 85, kindly see, my lord. The most important part which, my lord, I'll place now in that. I'll read slowly, my lord. As per police requisition received from so-and-so under so-and-so for dying declaration, I, Dr. So-and-so of Jugijan, have recorded the dying declaration of Ruby Pandit, wife of Sri Pijus Pandit, at 10:30 a.m. on so-and-so in presence of, my lord, this is important. Now this Gita Devi is not there, my lord. Only Ajit Burman, Sikha Pandit not examined, Pijus Pandit as per IOM not in the hospital. Now the fourth witness, the nurse, is not here, my lord. But she signs the dying declaration, my lord. She signs the dying declaration. So, my lord, if I'm writing a dying declaration, my lord, I'm saying that I have recorded, I have mentioned about 3 witnesses. Now, where from the 4th witness this Gita Devi comes, my lord? The nurse, my lord?
Page 86.
That is what, my lord. I'll just take back your lordship to Gita Devi's statement once again, my lord. Once again, I'll take the statement of Gita Devi, my lord. Now, my lord, this Gita Devi is page 30, PW 10, my lord. My lord, 31, the cross part, my lord. The 3rd line, I cannot say who did write her statement. My lord, she rightly deposed before the court in the cross-examination because, my lord, she was not present. I put my signature after writing. I have forgotten who did tell me to put my signature. I did not notice who take a term impression. So, my lord, if a witness is not there, my lord, this is clear. I did not notice who took her statement. Thumb impression, my lord. That is why the doctor did not endorse, my lord. My lord, this dying declaration, because what my learned senior colleague has time again read out the judgments of the Supreme Court, therein says that, my lord, the dying declaration has to be trustworthy, voluntary, and it should inspire full confidence of the court in its correctness, my lord, which is not there in this case. The other cases which my learned senior colleague referred were 85% burned and 90% burned, not 98 to 99%, my lord. And my lord, it is not a case of preponderance or probability. It is a case of proving the case beyond reasonable doubt, my lord. So this certificate, my lord, never says that, the doctor never says that I took the dying declaration. Following this, the certificate, the dying declaration is taken, my lord. Or even if we assume that the certificate was given thereafter also, but there also the doctor never says that he recorded the dying declaration. And when he records the dying declaration, the name of the 4th witness. So, my lord, my count is that if Sikha Pandit is not examined, Pijus Pandit, the husband, not examined, he was not there in the hospital, my lord, Sikha Pandit not examined, and the doctor did not spells about Gita Devi in the dying declaration that in presence of these persons I have recorded, meaning thereby, my lord, the correctness of this dying declaration cannot be taken up. And that, my lord, most important, the judgments which I placed before your lordship was that if a 98 to 99% burn case is brought before a hospital, my lord, being a human being, being a doctor, my lord, we take him as a god, my lord. He puts the painkillers and other important medicines, my lord, to at least give some relief to the patient who is in a great pain and agony. And then, my lord, the Supreme Court time and again says that, even the doctors also says that she cannot. If these are given, she cannot. And the doctor says that he has given first aid, my lord. Now, my lord, the prosecution should have proved the case of medical evidence saying that no, these were not given to the patient. So now she is in a state of giving the evidence. But that part they need to place. Because in a criminal jurisprudence, my lord, an accused is not required to speak from day 1 to day last, my lord. It is the prosecution who needs to prove the case beyond reasonable doubt. If I remain silent, I can. Because, my lord, even at this stage of 313, if I stand like this, my lord, it is not presumed that I have admitted something. Court will definitely record my denial, my lord. So, meaning thereby that the prosecution has to lead its own evidence to prove the case and convict the accused person. But hearing the discrepancy which I placed on record, my lord, this, my lord, could not be taken, my lord. And as far as that part is concerned, my lord, the story which they have created about the egg, my lord, has not been substantiated by any accused. The interested witness, I say informant being the interested witness, has brought this. However, the husband in his cross, my lord, Piyush Pandit in the cross has said that I have not stated before the police that my wife has stated so. So for the very first time in the court, my lord, he has brought that part, my lord. If I take a lordship to the statement of Piyush Pandit, my lord, the husband of the victim, my lord, page 26, in the cross part, last line, my lord, he says that no, I have not. Piyush Pandit, my lord, page 26, my lord, last part, my lord. Last 4 lines, my lord. My wife and I did not state before police that when Shamali was going after taking egg, my wife has caught her. So this is something which has been brought additionally in the court, my lord. But before at the time of 161, it was never. So they did not state before the police. Meaning thereby that the story of an egg, my lord, cannot be brought into, my lord. Because nobody has stated. It's the informant who is this brother-in-law of the victim, my lord. So he is an interested witness. This husband is an interested witness. So, my lord, the contents of the dying declaration, my lord, cannot be taken into. This is mumble submission. I'm obliged, your lordship. Plans to already placed.
Lordship, may I reply only on the point then? Doctor has, Lordship, one point that doctor has not recorded a dying declaration, whether that question was put to him in process of examination. My lord, may I take your lordship to the evidence of the doctor once, PW4, your lordship. Page 18, second paragraph. At the time of examination of victim, I also recorded a dying declaration of victim in presence of witnesses as she was found willing to give the statement and as she was also found capable for giving statement declaration. So whether it was put to him, nothing I have seen in cross examination, but you have not recorded a dying declaration. Nothing was put to him. And Sikha Pandit, lordship, that Bhumi Devi, her signature is there at page 85, your lordship, at page 86. Her signature is there, very much there, madam. And he is talking about the interested witnesses, but they were not present at the time of recording a dying declaration. So where is the question of tutoring, my lord? If they would have been there in the vicinity of the deceased, my lord, there is a possibility of tutoring, my lord.
One written arguments. Written arguments. Huh? Can you give your written arguments?
Yes, my lord.
Written arguments. How many days you
If
require?
lordship wants, my lord, we'll give a written argument.
How many days you require?
At least, my lord, 7 days.
7 days. You're saying 7 days.
Written argument.
Lordship may fix any day after tomorrow, any day. Tomorrow is Thursday, tomorrow is Wednesday. Friday, Pariba.
But Mr.
My lord, my submission is there.
Yeah.
My lord, in this case, with utmost respect, I would like to highlight the fact. In respect of the criminal intention of the present appellant. As far as the prosecution evidence is concerned, your lordship already came across about the prosecution witness. But in the prosecution witness, there was, if a man is to be convicted, the onus of his commission of the offense must be established. And his enmity of the crime, under what circumstances this man has committed the offense, has to be considered into or taken into consideration. But in this present case, my lord, if your lordship kindly have a look, your lordship has already gone through this entire evidence, but not a single word uttered by the prosecution witness about the enmity with the present appellants. Not a single word, either in the examination chief or in the cross examination. So unless there is an enmity in between the two parties, the prosecution and the disease victim, my lord, how this offense, grave offense is committed, that part has to be considered. In the judgment, it was wrongly, in the last part, in the judgment, it was wrongly inferred by the learned court below that the prosecution could establish the case, but undoubtedly it is beyond reasonable doubt it was not established as per the evidence of the prosecution. That is what I mean.
Mr. Talukder, Learned Counsel for the appellants. In criminal appeal 287 of 2019. Also heard Mr. A. Diwari, Learned Amicus Curie, in criminal appeal J number 15, 2020. Also heard Mr. B. Buyan, Learned MS B. Buyan, Learned Additional to the Assam. Part in part. Please for further hearing again. You want it on Monday or Tuesday?
Monday, Tuesday, meeting.
My lord, sometimes may be given, otherwise very difficult.
Monday I can.
29th.
Okay.
Like,
It will only not restricted to giving written submission. my lord.
No more arguments.
12,
Nia matter, my lord.
NIA.
NIA, my. Good is present.
And appears for the parties. List up to 2 weeks. 3 weeks.
seventeen,
What is this?
Government of Assam matter, your lordship, it has been, might have missed it, my.
Bit of it. Oh. Oh. Mm.
Did it.
None appears for the parties. This the matter. Two months. Single bench at 2.
The Lordship will recall this is the disciplinary proceeding matter in LIC. And arguments had otherwise been concluded, my lord. Only my reply was remaining. But just to give a quick refresh our memories, my lord. The challenge was that the submission on behalf of the petitioner was primarily that since he is merely a development officer, I have in fact prepared a very brief note also for your lordship's convenience. Once I conclude, I'll place that. But the submission on behalf of the petitioner was that since he is merely a development officer, as your lordship is aware, in the life insurance corporation, the role of a development officer is very, very limited. He has to groom the agents. There are agents under him. And his entire role is towards development of the business. Everything else is done. The actual procurement, as we see in our day-to-day lives, it is the agents who ultimately do all the work on the field. And ultimately, once the check is issued, the approval of the policy itself is done at higher levels. And once it is approved, the insurance policy is issued. Now, here was a case where there were some checks issued which were not approved. And those amounts were lying with the LIC, which they should have returned to the persons who wanted to make those insurance policies. They were not returned. Those amounts were lying in the account of the LIC. Now, it was at that stage, my pleaded case is that some of my seniors indicated to me that why don't you utilize these amounts for some other policies? And if you can make use of these amounts instead of simply lying there in the LIC, since they have not been returned. And that is where ultimately the entire blame has been put on me. Obviously, it was done by the agents. I could, because as a development officer, I could not have done anything. Approval was at higher levels. Now, when the proceedings were initiated, again, this is something which is very difficult to establish before your lordship, but my pleaded case is that it was at the instance of the higher officers that I motivated my agents to ultimately get these policies done, get these amounts utilized for other policies. And that is exactly how it happened. And ultimately, when it was the turn to put the blame, the entire blame has been put on me. Neither any of the agents have been proceeded against, nor any of the approving officers have been proceeded against. And if your lordship recalls,
Yes.
if your lordship recalls, the penalty imposed is twofold. One is recovery of the entire amount. When there is no allegation, if your lordship looks at the charge sheet or the entire proceedings, I even refuse to, I admitted that an entire case of LIC before your lordship is that since he has admitted, nothing remains. I admitted that, yes, it was an error of judgment on my part. It was a mistake on my part. But what is the mistake? The mistake attributable to me is to motivate the agents at best that utilize these amounts and make fresh policies. There was no actual loss to LIC. Never. Therefore, in the charges that your lordship sees, there is no allegation of misappropriation against me. So if there is
Yes.
when the allegation of misappropriation itself is not there, the reason being there is no actual loss to LIC. How could the question of even recovering any amount from me arise? So therefore, in my respectful submission, and on this account, on this issue,
The LIC, my learned friend has been very fair on that. He has not even tried to remotely indicate that there has been any actual loss. Because naturally, the respondents now at this stage of arguments cannot improve upon the case beyond the records. The records themselves do not disclose any allegation of misappropriation. So if the allegation of misappropriation is not there, the question of recovery cannot even arise. So in my respectful submission, my lord, in my humble understanding, the penalty of recovery has to go in any case. What would remain is, if the penalty of recovery goes, what remains is the penalty of removal. For the purpose of removal, one of the basic principles guiding the whole law relating to disciplinary proceedings leading to imposition of penalty, as your lordship is aware, is what is the extent of the gravity of the offense? Assuming everything that I have admitted, what is it that I can admit? I cannot admit what the agents have done. I cannot admit the approval of those policies by the higher authority, because these are not even my roles. My role at best could have been to motivate, or to use a harsher word, at best I have instigated these agents that utilize these amounts which are lying in the account of Life Insurance Corporation. You utilize these amounts to make fresh policies. That has two aspects. One is an element of, one can say that wrongdoing, assuming. The wrongdoing was that amounts lying in the account of LIC, utilize these amounts, make fresh policies in the names of some other person. But that wrongdoing also has a better side to it, that it was in the interest of LIC that this business was sought to be grown. I have nothing to gain in this process. I personally do not have anything to gain. The only gainer would be LIC, because they are getting fresh business. So in that kind of a scenario, was it such a misdeed or such a wrongdoing of such gravity that you would impose a penalty of removal? Because the provisions under which, if your lordship will kindly have that, it should be in the records, my lord. There is a Life Insurance Corporation India Staff Regulations 1960.
Yes.
If your lordship will kindly come to the penalties, the penalty that has been imposed are at page 24, madam, in that bunch of documents. The penalties imposed are under 39(1)(c) and 39(1)(f).
Yes.
If your lordship sees first C, subclause C, recovery from pay or such other amount as may be due to him of the whole or part of any pecuniary loss caused to the corporation by negligence or breach of order. So the ingredient, precondition is that there has to be a pecuniary loss to the corporation. Your lordship will not find any pecuniary loss, because it was all that was done was money lying here, taken out, utilized for making fresh policies. So there was no pecuniary loss to the corporation. So 39(1)(c) will automatically go because of total non-application of mine. Now what remains is F. Removal from service which shall not be a disqualification for future employment. The question that would arise is, why not A? A provides for censure. B, withholding of one or more increments either permanently or for a specified period. Because of the gravity of the offense, at best, it was an error of judgment on my part. And your lordship is aware
of all the judgments, I am not troubling your lordship with the judgments, that if it is an error of judgment, on my part, what was it? On my part was, I initiated or rather motivated utilizations of these monies lying idle in the bank account for the purpose of making fresh policies. It is at best a mistake, at best an error of judgment. There is no deliberate or willful act on my part or misconduct on my part to bring a bad name to LIC. It cannot be brought within the definition of the word misconduct. It is at best a mistake, at best an error of judgment. So naturally, they ought to have applied their minds as to why not A, why not B. Your lordship will not find in the order imposing penalty, your lordship will not find any mind being applied. All they have gone by, right from the beginning of the proceedings to the end. Even I refuse to even cross-examine any witnesses in good faith. Also, your lordship will find show cause notice. I said, yes, I have made a mistake. Charge sheet, yes, I have made a mistake. Proceedings going on. No, I don't want to examine any witnesses. It was all in good faith that I made these admissions. Because, of course, it is very difficult to establish or prove. These were all done when the higher officers told me that these amounts are lying idle. Utilize it for making fresh policy, if you can. And these are things I cannot do on my own. As I said, the agent has to get the policies done. He will interact with the customers. Ultimately, it is done by the agents. Approving authority is someone else sitting above me. The development officer has no role when it comes to approval of a policy. So why not A? Why not B? To that extent, your lordship will not find any application of mine in the entire decision-making process. So therefore, my lord, in my respectful submission, at this stage, my lord, may I place I have prepared a very, very brief note for your lordship's convenience. Yeah, could be. The entire case in a nutshell, my lord, I have placed it before your lordship.
Yes.
So therefore, my lord, in my respectful submission, the first penalty of recovery goes automatically because 39(1)(c) does not even get attracted. And the penalty of removal, there is no application of mine to the extent of the offense itself, the gravity of the offense, or whether it would at all come within the definition of misconduct, or whether it would amount to an error of judgment. All these things, there is a total non-application of mine. So therefore, my lord, even the penalty of removal, and there is no application of mine as to why it will not be 39(1)(a) or 39(1)(b). First, they have to, any prudent man, reasonably instructed in law, would first look at what is the gravity of the offense. If it is of such nature, what are the penalties? If it can come within the purview of error of judgment, why not A? Why not B? Why not C? And then you would come to the extreme. Only when first satisfaction is arrived at that the offense itself is of such magnitude that the highest possible penalty needs to be imposed. That satisfaction has to be there first. Only thereafter, the penalty, as drastic a penalty as removal, can follow. So to that extent, your lordship will not find any application of mine in the entire decision-making process. So that is my respectful submission, my lord. This is a case where perhaps the penalty of removal is too harsh a punishment and your lordship is aware that when the punishment is disproportionate, if your lordship so desires, I can give the citations quickly. I have it, but I didn't want to unnecessarily burden. I think while I was making my submissions initially, I had given this citations. Your lordship might be having it in your lordship's notes.
Yes. Yes, I have.
On error of judgment, my lord, I had given two case laws. One is 1992 volume 4 SCC.
Yes.
1992 volume 4 SCC, page 54. This is on error of judgment. Your lordship will find the relevant paragraphs are at paragraphs 5 and 6. And following the principle laid down here, there is a judgment of our High Court, my lord, which also I had given. This Girish Chandra Sharma, this 2006 volume 1 GLT 235.
Yes.
Here the paragraph is para 27. This is again on error of judgment. And regarding punishment being disproportionate, I had given that famous BC Chaturvedi case, 1995 6 SCC 749. This is on the proportionality of punishment. It has to be proportionate to the allegation, proven allegation. 95 6 SCC 749. The relevant paragraphs here are 12, 13, 17, and 18. This is on the principle of proportionality of punishment. This one, these two principles I'm placing before your lordship for the purpose of removal. So far as the recovery is concerned, it has to go in any case.
Yes.
With that, my lord, I would reiterate my prayers. The penalties have to go. Now, otherwise, he has already retired from service. He has reached the age of superannuation. So the only benefit that he will have is the satisfaction of having retired honorably. And maybe a little bit of pecuniary benefits, retirement benefits that might come to him. Otherwise, he has nothing to gain at this stage. He has already crossed that age. Deeply obliged.
My lord, may I please your lordship, prior to the issuance of the charge sheet, my lord may kindly consider my affidavit in opposition. I submitted, although my lord, I again reiterating that submissions, what I made on that day. Prior to coming to the SOCOS, my lord, this is a conduct of the petitioner. On each and every 4 occasions, he admitted the charges and assured the LICI that I will refund back. Prior to imposition of the penalty of the SOCOS to the penalty was issued with the claim that we are proposing a penalty of removable from service with recovery of 21 lakh. Against that, he stated that reply, I will refund back with interest. Now coming to the High Court in a writ petition, my lord, if he says that I have not done anything, how it is, record will not say. My lord may kindly come to page page, my lord, 15 of my affidavit, of my affidavit. This is the letter of the petitioner Depriya Das, annexure 2 of my affidavit in opposition.
Yes.
There is a shock cause issued because his conduct was like that. He collected his check from the customers, did not deposit to the LIC account. With due regards, I would like to submit my explanation to your letters number dated 10/9/2015. That's sir. I have gone through the irregularities pointed by your good office and I admit to have done the same. First admission. But under business compulsions, in this connection, let me admit that amounts lying unutilized in block deposit depositor and adjusted against policies on the life of other persons with the verbal consent of the depositors. The act was done with the sole interest of procuring more business under my organization. Moreover, I had also committed to all the depositors now complainants. They are complainants because he is not refunding their dues to them at an early date. However, I could not pay them within the committed period due to financial problems. Those financial problems, petitioners faced by me for a long time, owing to the ongoing health problems of my ailing father, who stays with me and is 89 years old. However, after having learned that a complaint has been lodged at your office by one of the complainants, I had immediately deposited rupees 5 lakhs only in cash by the surrender dated to me. Now I request to kind self to allow me to refund the balance amount with a further request to give me time up to the month of November 2015 only to arrange the funds repaid pay. He did not repay, payment repaid, so charge sheet was issued. And the charge sheet is at page 29 of the petition. In details, what are the policies he has done this out. Then, my lord, against the charge sheet, page 29 is the charge sheet. And against the charge sheet, my lord, what he replied, petitioner, my lord, his reply, I am coming to page, directly coming to the page 38. Second paragraph is reply. Page 38. 38 is reply. Second paragraph. At the outset, I do admit the charges leveled against me, allegations, violation of the rules of the corporation. Violation of the rules of the corporation is admitting. Points have been raised on my honesty, integrity, faithfulness towards corporation is discharging my duties. In this connection, I'd like to express my. Well, I'm not going in details. Next, I'm coming to page 39 bottom. Because the submission made by the petitioner's counsel, it is a collective responsibility. Was his reply, page 39 bottom. However, whatever lapses or irregularities are pointed out, I am shouldering my all responsibility. Not collective responsibility, all responsibility. And I assure your good self that I will make arrangement to refund all amounts to the concerned policyholder within a short time. There is no spar when he returned. I will not allow anybody to defend LICA for my activity. So it is a very serious offense, my lord. Good faith, I am giving the policy's check and you are utilizing for your personnel, your other salesman, and now the blaming the LIC. Then, my lord, I am coming to his, it is the second, my lord, admission. Third admission, my lord, I am coming to page 30 of the affidavit. Page 30. My affidavit in opposition. It is dated 14/6/2016.
1 minute.
My affidavit, page 30.
Yes.
This is a letter of the petitioner to the inquiry officer. Thank you very much. Smooth conduction of the inquiry proceeding held on 7/6/2016 and giving me one more opportunity to submit anything in support of the statement of submission. Sir, I have nothing to add more in my self-defense. I have already communicated my submission by letter dated so-and-so, which is crystal clear to arrive at a decision regarding acceptance of the charges leveled against me. However, I once again reiterate my decision and like to reaffirm that I am accepting the charges leveled against me without any pressure. Without any pressure. No one has advised him to admit from any corner. As I love my organization, I have admitted the charges and I will make refund all amounts. Till date, he has not refunded. There is no submission repetition refunded. Due to the complaint with the interest within very short time, again, I assure with you, type of irregularity will never occur in future. Under the circumstance, I request you good self, kind enough to consider my case sympathetically. Last admission, my lord, I am coming to the reply to the shock cause to penalty. At page 55 of the writ petition.
Yes.
Coming to that, my lord, kindly consider page 54. What is the shock cause to the penalty? Page 54, what is the penalty proposed to impose upon him? I am coming to the last paragraph of the page 54. Now, therefore, before proceeding further, last but one, my lord, above one, and whereas while differing with the findings of the inquiry officer and provisionally holding this charge-sheeted employee guilty of all the charges leveled against him, I, the disciplinary in the case, having power under so and so, so and so, so and so, dare to provisionally propose to impose upon C. Deeprover Das the penalties of recovery rupees 21,82,846 in terms of the regulation 81C and removal from service which shall not be a disqualification for future employment in terms of the regulation 39(1)(f). In reply to say this, of course, his submission is page 55. Shokos notice dated 31/3/2017. I am in receipt of your Shokos notice dated 31/3/2017 and noted the contents they are in. In this regard, I would like earlier denial as recorded in the preliminary hierarchy held on 26/12/1994, appellant cannot now permitted to resign from the admission made before the inquiry officer. Plea to reopen the inquiry has been rejected by the appellate as well as the revisional authority. Thereafter, it was not even argued before the learned single judge. The learned council had confined the submission to the quantum of punishment. In letters, patent appeal division bench declined to reopen the issue. In such case, we are not inclined to exercise our extraordinary jurisdiction under Article 136 for reopening the entire issue at this stage. Such power is reserved to enable this court to prevent grave miscarriage of justice. It is normally not exercised when the High Court had taken a view that reasonable possible the appellant has failed to demonstrate any perversity of the decision rendered by the single judge and division bench. So, my lord, the writ petition preferred before the Honorable Supreme Court, SLB, is dismissed last week. This is my submission. And after admission, my lord, what required to be proved? And once he has assured that I will refund interest, and there is no whisper in the writ petition counter this admission that when, how he has refunded. So the amount liable to be recovered from him. This is my also.
But I'm in fact grateful to my learned friend for bringing up this issue. This gives me an opportunity to clarify the position. Both the judgments that has been placed by my learned friend, the lordship will find that the charge itself is of misappropriation. And it is the misappropriation, charge of misappropriation that was admitted. That was what I was trying to bring it to your lordship's notice. My learned friend is pointing out that I volunteered to refund. Your lordship will, let me give an example. My learned friend has issued a check in favor of LIC for making an insurance policy. That insurance policy is not approved by the higher authorities. The amount is lying with LIC. Now that amount, I have instigated the agents with the approval of the higher authorities. Let us say that amount, I've made a policy in his name. What I have volunteered to refund is out of goodwill. That is why when the first allegation comes, I say that I will not allow any disrepute to come to LIC. I will make the refund. What I was refunding was this money, check issued by him in favor of LIC, which has been diverted to make a LIC in his name. It is from my pocket I am refunding. That is why your lordship will find neither in the show cause notice nor in the charge sheet, there is no allegation of misappropriation. Your lordship will kindly have a look at the show cause notice, madam, page 26. There is no allegation of misappropriation, even a whisper of misappropriation. That is exactly what I was trying to submit before your lordship. In fact, I'm really grateful to my learned friend for having pointed out this aspect. All the judgments pertaining to admission, it is an accepted principle of law that facts admitted need not be proved. But what has to be admitted? The charge. Here the charge is not of misappropriation that I have taken away, siphoned off money, which ought to have been, which belonged to LIC, that I have siphoned off. The charge is that you have diverted funds. When the charge itself is not of misappropriation, how can I admit to misappropriation? If your lordship sees, the show cause notice is at page 26, not even a whisper that I have misappropriated. If your lordship peruses just to refresh our memories, my lord, the original show cause notice is at page 26. I'm not troubling your lordship with this. Your lordship may just make a note. Neither in the show cause notice nor in the charge sheet is there any charge of misappropriation. So what I was volunteering to refund was from my pocket to the person whose money has been diverted for making some fresh policy. And that is why I say that my father has been ailing. I was unable to give. I went out of my way to protect the name of LIC. If your lordship sees, the language used is that I have already refunded 5 lakhs if you lodge, the show cause notice is at page 26, there is no charge of misappropriation. And page 28 is what my learned friend read out. What do I say here? My admission can be only when there is a charge of misappropriation, then one can say that I have admitted to misappropriation. When there is no charge of misappropriation, how can I admit to that? What I am saying here is, I have refunded 5 lakhs. I would like to refund further. I will not allow any disrepute to come to the LIC. That is what I say. Where is the question of any admission of misappropriation on my part? What I admitted to is the allegation of diversion of funds. So therefore, these judgments rather help me. That is my respectful subject.
But Mr. High Court, then a senior counsel, assisted by
S. Bishwakarma.
S. Bishwakarma, then the counsel. Also, Mr. S. Nath. Then the counsel for respondents for 1-4, present conclude. Just a minute.
Obliged.
To hearing.
But in this matter, I had concluded my part on last several occasions. The Agriculture and the Finance Department of the Government of Assam, they have been taking adjournments.
He
I-
also non-appears.
I think he was here. Asil, no? No. He was here, but I don't know where he is.
Nayak, is it Nayak?
Nayak. In fact, there was an observation.
What was this about?
But if your lordship so desires, I can quickly refresh your lordship's memory. The issue before your lordship was like this, madam. The petitioners are all presently serving in the Department of Agriculture, Government of Assam. They were originally serving in the Assam Industrial Agro Industries Development Corporation. It was a corporation by the name of Assam Agro Industries Development Corporation. This was an organization which was one of the few public sector undertakings in the state of Assam, which was really doing a profitable business in the state. There was a policy of the government of Assam right from its inception. This organization came into being in the 70s. There was a policy of the government of Assam that all the purchase of agricultural inputs will be routed through this PSU. And this had, in the agriculture sector, it has set up such a beautiful infrastructure throughout the state, even in the remotest corners. It was catering to all the farmers, all the agricultural requirements. And naturally, it started doing very well. But over a period of time, the government itself started violating its own policy. And it started making procurements through private parties. It started floating tenders, started awarding contracts to private parties. And that is when this organization gradually started suffering. In fact, there was a PIL file by a former chief minister of the state, bringing all these facts into to the notice of this honorable court. There is a judgment of the division bench of this honorable court saying that we hope and trust that the government will go by its own policy in the better interest of the organization. In spite of that, there were violations. Ultimately, once again, tenders started getting floated. The employees some of the petitioners are who are before your lordship, they got together, they filed writ petitions saying that these tenders themselves, NITs themselves are in violation of the government policy. In many cases, this honorable court interfered. Once again, assurances were given before this honorable court, again violated. Ultimately, in 2006, a decision was taken to close down this corporation. Again, my lord, these employees hesitated that how can you close down such a profit-making organization? But ultimately, since it was a matter of policy, there were hesitations resorted to, there were memorandums submitted, representations submitted. Ultimately, what they did was, they said that we will protect the interests of the employees. And the policy that was formulated, two options were given. One option was either you can go for voluntary retirement, or if you don't take the voluntary retirement package, we will fully mitigate your service conditions by absorbing you in government departments commensurate with your qualifications and experience. Now, based on this, that all service conditions will be fully mitigated, one set of employees opted for VRS. We are the people who opted for re-employment, absorption in other departments. Now, although we opted, they closed down the corporation, but they did nothing with us. We ultimately approached this honorable court, filed a writ petition. And this entire narration that I have made is, your lordship may just make a note. This entire narration, your lordship will find in the judgment passed by this honorable court in WPC number 3336 of 2007. And that is annexed to the writ petition as Annexure D, page 35. This entire narration of the facts that I have made is recorded in detail to the extent of how the government itself violated, how the PIL was filed, how ultimately it was decided to close down, how an offer was made to absorb us with all benefits. And accordingly, a direction was issued in this writ petition to absorb us and to pay our arrear salaries, etc. And this policy itself was taken note of, that all conditions will be fully mitigated. In spite of that, they did not.
Let us see the direction.
Direction, my lord, will find, if your lordship will come to page 35. The judgment starts at page 35.
That I have.
Now, your lordship will kindly turn to page 64. In fact, my lord, the relevant portion starts at page 63. The policy is taken note of. Towards the bottom, your lordship will find a sentence, clause 9 thereof having a definitive bearing on the present adjudicatory process deserves to be extracted. Then clause 9 is extracted. A section of the employees of some SLPs who may be absorbed in the state government departments will not be entitled to the VRS package. However, for the period of service rendered by such employees in the SLP prior to absorption in the government department, she will be paid the area salary, etc. They will not be eligible for any other component of the VRS package, as their problem of post-SLP service rehabilitation will be fully mitigated by the employment in the government departments. And this was accepted at para 31 down below. Clause 9 is categorical to the said effect, which clarifies that they would not be eligible for any other component of the VRS package, as their problem of post-SLP service of rehabilitation would be fully mitigated by their employment in government department. And having held thus, my lord, the direction at page 69. All the case laws were discussed, how the state is supposed to act as a model employer, and all those things have been discussed. The famous Kapila Hingorani case is taken note of at para 40 at page 68. Thereafter, my lord, page 69, para 42. In the above factual premise and in face of the determination made herein, this court is persuaded to hold that the petitioners are entitled to be considered for absorption against the vacant posts enumerated in the list appended to the aforementioned letter dated 2/6/2007. In terms of the representation promise made by the state respondents for their redeployment, re-employment, following the closure of the corporation and affirmed by the cabinet in its decision on 22/8/2006, ordered accordingly. As the petitioners wait in bona fide expectation and understandably that with the sudden turn of events, they have been left high and dry with their families, the process as directed should be completed within a period of 6 weeks from the date of receipt of the certified copy of this order. Needless to say, the state respondents would also attend to their claim for arrear salary and allowances due to them before the closure, and following the quantification thereof, defray the same to them forthwith. The petition is thus allowed in the above terms. Now, in spite of this judgment, they did not do anything. We had to file a contempt case. After we filed the contempt case, they filed an appeal against this judgment. That appeal was also dismissed. And your lordship sees that the closure of the corporation takes place in 2006. The appeal, writ appeal, was dismissed on 15/7/2009, which is annexed at Annexure E, page 71. So the judgment of the Honorable Single Judge was upheld by the division bench.
Yes.
And ultimately, after the division bench judgment, a decision was taken that will be absorbed. In the absorption page, the decision to absorb, your lordship will kindly come to page 94. Your lordship will kindly come to, they will rely on this clause, madam. Page 95. They will perhaps rely on these two clauses. Clause 12, madam. Their services after joining the government posts will be governed by the existing rules and regulations applicable to the government service. So they are now trying to wipe out our past service. Entire service, somewhere on the verge of retirement. Some have in the meantime during the pendency of the writ petition retired. Now next clause, my lord. The petitioner's employees will have to give an undertaking in stamp paper or in the form of an affidavit about acceptance of the offer and terms and conditions before joining the government posts. So a coercive action that you will have to give an undertaking, only then you will get the employment. And interestingly, your lordship will find, if your lordship kindly turns the page, if your lordship kindly turns to page 96, your lordship will find that a copy of this is not marked to any of the petition. This is a decision taken behind the back. And these are the conditions that are laid down. Accordingly, your lordship sees, here is a situation where even pre-closure, for almost 48 months, they had not got salary. So right from 2006 was the closure. From 2002, they did not get salary. The direction of the Honorable Single Judge was dated 4/12/2007. They did not comply. The writ appeal judgment is 15/7/2009. No compliance. So all these employees are on the streets. And this is on instruction. I'm making this statement, my lord. Many of the employees had to take out their children from the schools because they could not even afford the fees. That was the state of affairs. At this stage, they forced these undertakings on us that you will not claim arrear salary for all this period. And it is for no fault of ours that there are judgments of this honorable court to absorb. They do not absorb, and they make us sign an undertaking that you will not claim arrears for this period for which we did not appoint you. You will not claim any benefits which accrue by virtue of your past service. You will be, they say in this at page 95, that you will be governed by the existing rules. One of the reasons was that they wanted to bring us out of the pension rules and they wanted to put us in the new contributory pension scheme. Your Lordship will imagine a situation, a man who is at the age of 58 and his entire past service wiped out. At the age of 59, he is made to sign this, forced to sign this undertaking. And we are in such a situation that give us the job, at least if I get the current salary, I can feed the mouths in my house. Under those compelling circumstances, I am not disputing or denying the fact that we did sign the undertaking. So after that, we pointed out, we thought that let us, whatever we get, let us take it first. And then we started submitting representations that how can you wipe out my entire past service?
Yes.
How can you wipe out my entire past service? Because what it entails, your Lordship is aware, for a government servant, his leave encashment, all his life, the leave that has accrued, by stroke of a pen, you are taking that away. The benefit of pension that I would have been otherwise entitled to under the pension rules of 1969, all the pension gets wiped out. Gratuity, several aspects, Malan. Then the salary for this period, because what was the policy? You will not get, if you do not opt for VRS and you opt for re-employment, your service conditions will be fully mitigated. When you say fully mitigated, you literally mean it, that you will, as if it is a continuation of where you left. And that is why the Honorable Single Judge took note of that, not only extracted that portion of the policy, in para 31, it has been recorded that you have made this commitment that all conditions will be fully mitigated. So therefore, the Honorable Single Judge issues a direction, and not only to absorb within, they have been left, the language employed by the Honorable Single Judge is, they have been left high and dry. Not only was the direction issued to absorb, the direction was to absorb within a period of 6 weeks, which they do not do. We file contempt, they file a writ appeal. Writ appeal gets dismissed. After that, they take another 2 years. So from 2006, for no fault of ours, you have kept us hanging. And now you say that from for this period, the gap period, which they want to now call the gap period, 2006 to 2011, they want to bring in the principle that no work, no pay. Will your Lordship permit this kind of a conduct? Will your Lordship allow them to wipe out our entire past service? The law also is pretty well settled. In fact, my Lord, the prayers that we have made, if your Lordship applies the principle laid down in that famous SI Ruplal case, which I had placed, my Lord, if necessary, I'll place it again. In SI Ruplal case, from Delhi police, one sub-inspector got absorbed in CBI or vice versa. I don't exactly remember the facts. But while absorbing, same thing was sought to be done. His past service was sought to be wiped out. The apex court said that he has been brought at par. He fulfills all the eligibility. So how can you wipe out his past service, which he has earned over a period of time? He has put in his service. You cannot. So if your Lordship applies that principle, the 4 prayers made in the writ petition will automatically follow. And that has been accepted by the Honorable Single Judge, which has been upheld by the division. When you say that, of course, the Honorable Single Judge could not have conceived of a situation that they will take away my leave encashment, they will take away the pensionary benefits that have accrued under. At that time, since the absorption itself had not happened, it was this Honorable Court could not have conceived of that situation. But when the word fully mitigated is used, it is obviously taken for granted that it will we move, the only thing that will vary is we move from one employer to another. From a public sector undertaking where the stakes of the state government are 50 and central government is 50, effectively a government organization. From a public sector undertaking, we move to a different employer, which is the government of Assam in the agriculture department. Otherwise, everything remains the same. So now that situation is being sought to be reversed, and we are sought to be treated as fresh appointees at the age of 57, 58, 59. And that is essentially, that is the challenge before you, Lord. And as I said, my Lord, that SI Ruplal, I'll quickly give the citation. I had placed it on the last occasion. Huh? 2000.
You placed a citation?
I had given the citation, and I had, I think I had placed the judgment also. 2000 volume 1 SCC 644. 2000 volume 1 SCC 644. Relevant paragraphs are paragraphs 15 and 16. So if this principle, as has been laid down by the Honorable Supreme Court, so, yes, I
Yes.
Just give me a moment. Relevant paragraphs are 15 and 16. Man. Para 15. We will now take up the question whether the appellants are entitled to count their service rendered by them as sub-inspectors in BSF for the purpose of their seniority after absorption as sub-inspectors in the Delhi police or not. Here, my lord, even to the extent of seniority is taken into account. We are not even claiming seniority. We have already noticed the fact that it is pursuant to the needs of the Delhi police that these officials were deputed to the Delhi police from BSF following the procedure laid down in Rule 5H of the rules and subsequently absorbed as contemplated under the said rules. It is also not in dispute that at some point of time in BSF, the appellant services were regularized in the post of sub-inspector and they were transferred as regularly appointed sub-inspectors to the Delhi police force. Therefore, on being absorbed in an equivalent cadre, this sentence is very important. Therefore, on being absorbed in an equivalent cadre in the transferred post, we find no reason why these transferred officials should not be permitted to count their service in the parent department. At any rate, this question is not rea integra and is squarely covered by the ratio of the judgments of this court in more than one case. Since the earlier bench of the tribunal relied upon Madhavan case to give relief to the deputationists, we will first consider the law laid down by this court in Madhavan case. This court in that case, while considering a similar question, came to the following conclusion. We may examine the question from a different point of view. There is not much difference between deputation and transfer. Indeed, when a deputationist is permanently absorbed in the CBI, he is under the rules appointed on transfer. In other words, deputation may be regarded as a transfer from one government department to another. It will be against all rules of service jurisprudence if a government servant holding a particular post is transferred to the same or an equivalent post in another government department. The period of his service in the post before his transfer is not taken into consideration in computing his seniority in the transferred post. The transfer cannot wipe out his length of service in the post from which he has been transferred. It has been observed by this court that it is a just and wholesome principle commonly applied where persons from different sources are drafted to serve in a new service, that their pre-existing total length of service in the parent department should be respected and presented by taking the same into account in determining their ranking in the new service cadre. Para 16. Similar is the view taken by this court in the case of R.S. Makashi and Wing Commander J. Kumar, which judgments have been followed by this court in Madhavan case. Hence, we do not think it is necessary for us to deal in detail with the view taken by this court in those judgments. Applying the principles laid down in the above referred cases, we hold the appellants are entitled to count the substantive service rendered by them in the post of sub-inspector in BSF while counting the service in the post of sub-inspector in the Delhi Police. The principle is that the posts are equal. Both of them might be different organizations. One is BSF, Border Security Force. The other one is Delhi, under the Delhi government. Now, otherwise, both are mentalities of the state. If that be so, a person having rendered service in his parent department, that cannot be wiped off. Here, the apex court has gone to the extent of even seniority. We are, before your lordship, we are not claiming any seniority at all. We are simply saying that give us what the pecuniary benefits that will flow by counting our past service. There is no further prayer before your lord. So, in a nutshell, my lord, this is the case, subject to what my learned friend
Are
submits.
you still in service?
Some, about 5 or 6 of them have retired. So, if your lordship allows the writ petition, they will be entitled to some amount of pecuniary benefits. And some have, I'm being told, my lord, 2 or 3 of them have even passed away in the way. So their family will get some benefit. This is a fight that has been going on since 2006. Almost 20 years now. We're in a very bad situation, my lord. In fact, this is one case which reminds me of perhaps why the constitution makers had to draft in the extraordinary jurisdiction of your lordships under 226. It is these extraordinary situations where justice has to flow from your lordships. We, instead of getting bogged down in narrow technicality, these are the cases perhaps even the state should rise above and give them the benefits. After all, they were their own. Agro Industries Development Corporation was their own baby. 50% stakes, it is recorded in the judgment. 50% shares belong to the central government, 50% to the state government. And the center, when ultimately this decision was taken to close down, the center surrendered its share at 1 rupee. The state should be equally magnanimous to give it. There are hardly 30-40 employees now left. So they should have by now perhaps risen above and said that we will.
Yes.
But subject to what my learned friend submits, my lord. If your lordship will kindly excuse me for 10 minutes.
Nayab here for
Lordship, I am appearing for Finance Department.
respondent.
I'm appearing for respondent number 9. Respondent number 5, Lordship. Subsequently updated.
Yes.
Before coming to submissions, Lordship, I would like to place the facts very briefly, Lordship. Lordship, may kindly see page 26(1), Lordship.
Page
26A.
yes.
Lordship, this is the notification for closure, Lordship, dated 26 September 2006. Lordship, as per cabinet approval on 22/8/2006, and in continuation of this department letter number so and so dated 37/2005, etc. The
Yes.
government of Assam is pleased to declare that the Assam Agro Industries Development Corporation Limited is closed with effect from 31/8/2006. Lordship, may see next page, Lordship.
serial number 11. Same notification, the Managing Director of Assam Agro Industries Development Corporation Limited, Ulupari, is requested to circulate this notification among the employees of the AAIDC Limited. Further, he is required to furnish the list of employees who have not allotted for VRS by indicating their designation, education, qualification, date of birth, date of superannuation, date of entry into service, and scale of pay, the list of assets, etc., etc. So, after this notification, Lordship, some of the employees applied for VRS, Lordship, and some of the employees they sought absorption in the government department, Lordship. Lordship will see that at page 29. Yes. Page 29, this is letter dated 2011-2006 by the Managing Director, Lordship. With reference to above, I have the honor to submit herewith the list of employees opted for VRS as well as the list of employees not opted for VRS. Lordship, here, Lordship will see in the next page, Lordship, the employees who opted for VRS, Lordship, that list is not annexed here. Only the list who have applied for, who have not opted for VRS, Lordship, that list is here. In this list, Lordship will get 86 numbers of persons, Lordship. So it is entirely on the decision of the petitioner's, Lordship, that they, instead of VRS, they opted for this scheme, Lordship. Then Lordship will see at page 35. This is writ petition 3336 of 2007.
That I've seen.
That Lordship will see the operative portion once again, Lordship. '69, Lordship.
One minute, 1 minute. Page 69.
Lordship, I'm coming to page 67, Lordship.
Uh,
One small paragraph I would like to read there, Lordship, paragraph 37. Paragraph 37, Lordship. A cumulative consideration of the above recorded input leaves no manner of doubt that the state government and the agriculture department in particular were clear in their notion that the feasibility of absorption of non-VRS optees of the corporation would have to be explored in terms of the recommendation of the committee. A committee was constituted in the meantime of the state public sector enterprise and accepted as an essential precondition of the closure. The proposal of closure of the AAIDC as communicated by the letter dated 37/2005 and notification dated 26/9/2006 indicating the cabinet's approval of the said recommendation read with the notification dated 15/2006 embodying the revised voluntary retirement scheme and the exercise of collecting the biodata of the employees who had not opted for the BRS, in my estimation, comprise a explicit promise to accommodate them in the state service against the post, which are commensurate with their academic qualification and experience. So it was the finding of the Honorable Court, Lordship, that a promise was made, Lordship. Then Lordship will come to the last portion, Lordship.
Nayak, one more before we proceed further.
Lordship.
Where is this? There was a close 9, isn't it?
Yes, Lordship. Lordship, I'm coming to that, Lordship. That is a part of the BRS scheme. BRS scheme.
Where is the scheme?
That is a scheme of 2006, Lordship. Lordship will get the scheme at page ইয়াতো আছে চাগে। Petition.
Is it in the writ petition?
It is not a part of writ petition, I think. But subsequent.
In your counter?
Let's see. It was a notification of
Make sure
2006
Make sure.
of the affidavit, Lordship.
Of the?
Filed by the
16 of the affidavit filed by the
Agriculture
Agriculture
Department, Lordship. Case,
1 minute,
16.
agriculture department, page 16.
yes,
16.
removal. Page 16, Lordship, Annexure 4. That serial number 9, Lordship.
Annexure 3.
Annexure 3, Lordship. Yeah. Serial number 9. A section of employees.
Yes.
No, this is not in specific of the Assam Agro Industries Development. Lots of people see the heading, notification, subject, revised policy on voluntary retirement scheme for the employees of state level public enterprises of Assam. So this is not for the specific corporation only, for others also this applies. Okay. Serial number 9, a section of employees of some SLPs who may be absorbed in state government, may be absorbed in state government departments will not be entitled to the VRS package. However, for the period of service rendered by such employees in an SLPE prior to absorption in a government department, he/she will be paid the arrear salary, wages, within bracket basic pay plus DNS allowance. They will not be eligible for any other component of the VRS package, as their problem of post SLP service rehabilitation will be fully mitigated by employment in government department. So it is there. Lordship will then see page 22 of that same affidavit. Lordship. Page 22, it's a notification dated 25th November 2010. Lordship, in partial modification of government notification number so and so dated 15 February 2006 on revised policy on voluntary retirement scheme for the employees of state level public enterprises of Assam, the governor of Assam is pleased to delete the provisions under para 9 of the aforesaid notification issued by the Department of Public Enterprises. Henceforth, paras 10, 11, and 12 of the aforesaid notification will be read as para 9, 10, and 11.
Yes.
So initially that was a part of that notification, but subsequently it was removed. Lordship.
After the judgment came.
Judgment came. Then Lordship will see the judgment, Lordship. Page 69.
Yes.
Paragraph 42. In the above factual premise and in the face of the determination made herein, this court is persuaded to hold that the petitioners are entitled to be considered for absorption against the vacant post enumerated in the list appended to the aforementioned letter dated so and so. In terms of the representation, promise made by the state respondents for their redeployment following the closure of the corporation and affirmed by the cabinet in its decision on 22/8/2006, ordered accordingly.
See this cabinet decision. Also.
Yes. Last paragraph, your lordship. C43. Needless to say, that the state respondents would also attend their claim for area salary and allowances due to them before the closure and following the quantification thereof, defray the same to them forthwith. The petition is thus allowed in the terms in the above terms, no cost. So Lordship will see here a direction was specific direction was there for payment of salary till the date of closure, Lordship. Paragraph 42. Lordship will also notice in this judgment, Lordship, only in terms of this judgment, Lordship, only a right to be considered for absorption was there. There was no specific right, no specific direction that please absorb them from such and such date. Only a direction to consider their case for absorption. Then Lordship will see the judgment passed in the appeal, Lordship. Lordship, I am coming to the operative portion, Lordship. Lordship will see at page 91. Paragraph 21.
Yes. 1 minute. Yes.
Paragraph 21, Lordship. Insofar as the present case is concerned, the respondent writ petitioners had opted not to be covered by the voluntary retirement scheme, but to await their absorption in different government departments. The course of action adopted by the respondents writ petitioners obliged the state authorities to consider their cases for absorption against such posts as may be availed in the light of their qualification and experience. Such obligation of the state authorities, in our considered view, flows from the clear and unambiguous contents of the several government communications and orders already noticed by us, under which such employees of the corporation who do not opt to be covered by the voluntary retirement scheme are to be retrenched only if their absorption in the agriculture department is not possible. In the present case, the materials on record do not indicate that the cases of the respondents, writ petitioners, are absorption were considered at all. The stand of the state is that there is no policy decision in force for absorption of the employees of the corporation in the agriculture department. The issue is not with regard to the right of absorption, but centers around a right of consideration and eventual absorption, if any particular employees is found to be suitable for a particular post, they may be available in the agriculture department. So division bench had affirmed that they only have a right to be considered.
Continue.
There is no right as such for absorption. And Lordship will most importantly a right of consideration and eventual absorption, if any particular employees is found to be suitable for a particular post, that may be available in the agriculture department. Lordship, even after consideration, the state authority were within the rights to cancel someone among within that list, Lordship, if he is not found to be suitable. Then, Lordship, I am coming to page 94, Lordship. Then Lordship will see at page 94, Lordship. Now, Lordship will, before I read this order, Lordship will say, in Assam, Lordship will not find any specific rule for absorption, Lord. So it is for the state government to pick the terms and conditions of rules of regularization, Lordship, rules of regularization, or be it absorption or regularization, Lordship. Accordingly, Lordship, in view of the order passed by the division bench, Lordship, government has taken a decision to absorb the employees, erstwhile employees of the Assam Agricultural Development Corporation Limited, Lordship. Before that, Lordship, I would like to place one order passed by our High Court, Lordship, in another case, Lordship, Lordship, this is a case, Lordship, filed by the other section, Lordship, the employees who opted for VRS of the same corporation, Lordship. Lordship will find their prayer at paragraph number 8.
Yes.
Paragraph number 8, the petitioners, I have already stated, Lordship, they are the employees who have opted for VRS. The petitioners have also made a claim for benefit under ROP rules 2010 to earn leave and encashment and 3 salary in lieu of 3 months notice. The said issue is taken up. Ultimately, Lordship, what the court will has recorded at serial number 13. I'm not coming to the other portions, Lordship. All the prayers were rejected. Serial number 13, Lordship. Does the ratio laid down in the case of so-and-so has no application in this case because as per the ratio laid down in the case of A.K. Bindal, B. Officer Supervisors IDPL Supra, the petitioners cannot be held to be government employees and therefore the notification of VRS cannot be said to have curtailed any rights accrued or vested upon the petitioner. So only the one line, Lordship. So far, till the moment they were employees of the corporation, Lordship, they were not government employees. They will become government employee only after absorption, Lordship, in a government department, Lordship. That is the line I'm only relying upon. Then coming to page 94, Lordship,
Yes.
of the writ petition. Lordship, this is the rule fixed by the government, Lordship, for absorption of the employees of the corporation. In pursuance of the judgment dated so-and-so, passed in by the High Court in WPC number so-and-so, read with judgment number so-and-so in WA number so-and-so, and order dated so-and-so, and order dated 11/12/2009, passed in WPC number 4715/2009, and as per approval of the cabinet in its meeting held on 27/8/2010, I am directed to convey the
Where's this cabinet decision?
page 94, Lordship.
No, yeah. Cabinet decision? Approval of cabinet?
Approval of the cabinet in its meeting held on 27/8/2010.
Where is this?
Lordship.
Do you have a copy of this cabinet decision?
No, Lordship, it has not been.
Keep that in mind.
Lordship.
You keep that in mind.
Lordship. And as per approval of the cabinet in its meeting held on 27/8/2010, I am directed to convey the approval of the government of Assam for absorption of 69 numbers of writ petitioners, former employees of AAIDC Limited. Lordship, I must have noted that in that list, Lordship, there were 86 numbers of persons, Lordship. Here, Lordship, the number has came down to 69. Former employees of AAIDC Limited against the existing vacant post under Agriculture Department as shown in the list at Annexure 1 on the following terms and conditions. 1, only the employees who have been drawing pay in the regular pay scale and did not opt for VRS will be eligible for absorption. Casual contractual employees will not be considered. 2, the employees will be considered only against the vacancies which are not to be filled up through APSC. 3, qualification and pay scale of each employee of AIDC Limited will be considered vis-a-vis the qualification and pay scale of the vacant post in the Department of Agriculture. 4, a list be prepared indicating employee-wise available suitable vacancies against which she can be considered. 5, the employees who are not found suitable for any of the posts carrying same pay scale and qualification will be offered lower post if found suitable for lower post in the Department of Agriculture, subject to acceptance by the employee individually by submitting an affidavit. 6, the appointing authority may adjust the suitability of the candidates by their academic qualification, experience, and by holding written test, typing test, other appropriate test interview if felt necessary. That the employees of AIDC will be considered for absorption on the basis of their merit cum seniority. However, the appointing authority can accord preference to the employees having better qualification, experience, ability. 8. The employees absorbed will be given pay at the department by the Department of Agriculture only from the date of joining in the Department of Agriculture, and they will not be entitled to any pay during the gap period, that is from the date of release by the AAIDC Limited till the date of joining in the Agriculture Department. 9. The employees absorbed in the Department of Agriculture will be placed at the bottom of the list in their respective cadre ranks for the purpose of seniority, and they will not have any claim of seniority over and above any of the employees already serving in the department. Then the inter-se seniority amongst the employees so considered and absorbed will be on the basis of the select list prepared by the appointing authority in order of merit. 11. Those who will not be suitable for absorption in the department will be compulsorily retired, retrenched. 12. The services after joining the government post will be governed by the existing rules and regulations applicable to government servants. 13. The petitioner's employees will have to give an undertaking in the stamp paper or in the form of an affidavit about acceptance of the offer and terms of conditions before joining the government post. 14. The candidate so appointed will not be governed by the existing Assam Service Pension Rule 1969 and orders issued thereunder from time to time. She will have to give an undertaking as per format at Annexure 3 before joining that she will abide by the new pension scheme of the government, which has been formulated in the line with the contributory pension scheme announced by the Government of India as per Finance B Department notification number so and so dated 6 October 2009. While absorbing the petitioners employees, the reservation policy of the state government should be kept in mind. Lastly, Lordship will see last paragraph, approval of Finance SIU Department for filling up 53 post of junior assistant, district level has already been considered so and so. I'm not concerned. Lordship will see this is a part of the writ petition, Lordship, and this is not under challenge, Lordship. So these are the terms and conditions fixed for the petitioner's Lordship, and this is not under challenge. Then Lordship will see at page 104.
1 minute. Page
104, Lordship. Lordship, this is an order dated 21/3/2011, Lordship. This is the order, Lordship, by which the petitioners were absorbed, and here your Lordship will find 46 numbers of persons, Lordship. Yes. Now Lordship will come to the prayers, Lordship. Page 24, Lordship. Lordship will see prayer number 1. To give effect to the absorption of the petitioners from 26/9/2006 and to grant all consequential service benefits, including arrear services with effect from such date. Second prayer, Lordship will see fix the pay scale of the petitioners in the Agriculture Department commensurate with earlier scale of pay, which they were drawing in substantive post in the AAIDC. 3. Mandamus shall not be issued directing the respondents forthwith place the petitioners under the scheme of the Assam Service Pension Rule 1969. 4. Calculate amount of gratuity of the petitioners from their date of joining in the AAIDC. 5. Lordship, pay the salary of the gap period with effect from the date of closure of AIDC Limited to the date of absorption of their absorption in the Agriculture Department. Now, Lordship will see here, paragraph 3, paragraph 4, paragraph 5, all these are parts of that notification, Lordship, the rules issued framed by the government, Lordship. And these rules are not under silence, Lordship, even though the petitioner is claiming those benefits contrary to the rule fixed by the government, Lordship. So far as the first prayer is concerned, Lordship, their claim for absorption from the year 2006, when the corporation was closed, Lordship. Lordship has seen the judgment passed by learned single judge as well as by the division bench, Lordship. It was quite clear that, Lordship, till the date of absorption, Lordship, their only right was for consideration of absorption, not for actual absorption. Absorption would take place only on the date of issuance of that notification, Lordship, that is 2011, when the actual order of, Lordship, order of absorption was issued on 21/3/2011, Lordship. This notification is also not under silence, Lordship.
Where is that observation order?
Lordship will see at page 104, Lordship.
Yes.
Then second prayer is, Lordship, fix the pay scale of the petitioner. It's in the Agriculture Department, commensurate with the earlier scale of pay. Lordship will see paragraph that list, Lordship, at page 97, Lordship. I am taking one example only, Lordship. At the serial number 1, he is Shishir Majumdar. Page 97, one table is there.
Yes.
Serial number 1, Lordship. Lordship will see at column number 6, the last post held with place of posting under the corporation, Lordship, assistant branch manager. The scale he was receiving, Lordship, 41209225. Now he has been given the post of at column number 8, Lordship, publicity assistant DDA, marketing, Khanapara. Now, Lordship, the salary, Lordship will notice the scale he has been given 3490 up to 8100. In the actual absorption order, Lordship, at page 104. Lordship, may kindly see at serial number 7.
Yes.
Lordship, may kindly see the scale he has been given, Lordship. 5200 to 20,200. So it is higher than what he was receiving under the corporation, Lordship. Lordship, what happens, Lordship? The settled principle is that once you are absorbed in the government department, Lordship, your seniority has to be placed at the bottom of the list, Lordship. So one person is, if the person who is senior to me, Lordship, and if my position is below him, Lordship, I cannot expect salary more than what my immediate person who is above me, Lordship, is getting, Lordship. So in some cases, Lordship, that happens. He has been given the scale, that particular scale, but as you cannot claim seniority, the person who is already in the seniority list, Lordship, you have to accept that your salary will be less than the person who is above you, Lordship. So in some cases, Lordship will see, definitely it is there, Lordship. Some persons are getting less salary what he was getting under the corporation, Lordship. Secondly, Lordship, third prayer, Lordship, under the new pension scheme, Lordship. Lordship, on this point, Lordship, I have not much to say. My only submission will be, if your absorption or regularization takes place after coming into effect of the new pension scheme, Lordship, then you are covered by you are not covered by the old pension scheme. Your service will be covered by the new pension scheme. On that line, Lordship, I will place 2-3 judgments, Lordship. serial number 5, prayer number 5, Lordship. Lordship, here he was claiming salary for the gap period, that is from 2006 to 2011, Lordship. Lordship must have noticed that judgment of single judges, Lordship. Here it has been clearly ordered to pay salary. Page 69, Lordship.
Yes.
Paragraph 43. Arrear salary and allowances due to them before the closure of closure.
Did you pay this?
That they have already received, Lordship. They cannot claim that they have not.
Before closure, we have got. What we are saying is, from 2006,
Gap period.
that gap period, it was not because of any fault of ours. This honorable court, honorable single judge, division bench was held, accepted our right from that notification. And it is therefore,
Later on, they deleted that particular paragraph.
that is what I was coming to. Your lordship will kindly see the date of the notification. It is after even the division bench judgment. Can it have retrospective effect? It was based on that notification that the judgment was passed.
No, my learned.
So it cannot have,
No, no,
the
no.
word used is deleted.
No, my learned friend should not make any submission that that notification was issued targeting them only.
No,
I have
I'm not
already
saying that.
said that 2006 notification was not only for the Assam Agro Industries Development Corporation.
True.
It was for all the undertakings of the state.
True.
So if subsequent notification comes, Lordship, and a particular clause of that earlier notification is modified or removed, Lordship, they should not consider that it was for targeting them only, Lordship.
No, I'm not saying.
It was for all the employees of all the corporations, Lord.
That is the.
So basically, these are my submission, Lordship. Although I was not prepared at all, Lordship, today. Lordship, on the next date, Lordship, I will place 2-3 judgments. I will not take much time, Lordship, 15-20 minutes. Lord.
How long? How much time you require?
No,
Let
no,
us
not much
finish
time.
it when the,
Just 15-20 minutes. So I will just place the judgment.
when it is fresh in the memory. Otherwise, again, next day comes again. Problem is.
I'll just place the citations, Lordship, nothing else.
In that case, let it be immediately, my lord, next week, next Tuesday.
Lordship.
Are you all right with that?
Lordship.
This Thursday, otherwise I would have prayed for day after tomorrow, but day after tomorrow, I'm in Itanagar bench. For something important.
In the meantime, try to catch hold of the cabinet decision, which I have already,
Lordship, Lordship.
which gave the decision for absorption of the petitioners. The cabinet decision,
Lordship.
that is
Of 2010, Lord.
1 minute. Where was that?
Page 84, Nikhil.
94.
90.
Yes, yes, 27/8/2010.
Lord. Lordship, I'll furnish a copy of that.
Okay. Heard Mr. I. Chaudhary, the senior counsel. Assisted by Mr.
S. Vishwakarma.
S. Vishwakarma, Learned counsel for the petitioners. Also heard Mr. P. Nayak, Learned standing counsel, finance department. And MS Arbora, Learned standing counsel, agriculture department. Stop. Heard in part. List the matter again on 30.
30.
30. Get a printout copy.
Agriculture